Your Lords, I beg to mention item number 3.
Yes.
May be given 3 weeks time.
What for?
Petitioner.
For what purpose?
We have to file rejoinder, but we couldn't get the instruction from petitioner till now.
Yeah, for the petitioner.
Yes.
Okay. You want an adjournment basically?
Yes. Yes.
Okay, up to 4 weeks.
I beg to mention item number 10 also.
10 also.
Yes. May be given particular date since
Okay. Up to 4 weeks.
particular date, Your Lordship.
Which date?
July. 31st of July.
31st of July.
Yes,
Okay, 31st of July.
Much obliged.
May I please, madam?
Yes.
I beg to mention item number 13, madam.
Yes.
Madam, I have taken consent from the other side, madam. Matter may be taken up to 2 weeks.
Up to 6 weeks.
2 weeks, madam.
Any urgency in the matter?
Madam, basically, this is madam cancellation of LPC, madam.
Oh, we'll take it out to 4 weeks.
All right.
Number 1.
Please, Your Lordship. So, in the matter in earlier occasion, I am the petitioner. I was directed to file additional affidavit to bring some records, my lord, allotment letters. So, due to non-availability of the petitioner out of station, I could not file today or before. So, I need to file this additional affidavit. Sometime may be granted, my lords. By earlier occasion order dated 18/5/23, I was directed to file additional affidavit. But I could not file.
On the prayer of Mr. U. Deka, legal counsel for the petitioner. 6 weeks time is granted for filing of additional affidavit as directed earlier.
Yes. Obliged.
Right. Yes.
Well, this petition is basically challenging the shifting of the district hospital. What had happened is, there was only to know the fact, I could not obtain that cabinet decision, my lord. Because it is the deputy commissioner who has taken decision to shift the district medical officer from Kalikopul Memorial Hospital at Hyoling, my lord, to Hawaii. So to that extent, my lord, because the cabinet has also taken a decision to rename the hospital after late Kalikopul's name. My lord. So now here is a deputy commissioner who says that he is trying to shift the DMO office. So only to that extent, my lord, I am on the verge of getting it. It is, I'm told the client is getting the cabinet decision within a day or two, my lord. I pray for
6 weeks?
4 weeks.
Okay, 4 weeks.
Yes.
On the prayer of Mr. Kritidana Kapisa, let us assume the 4 weeks.
Much obliged.
Item number 4.
Lordship, yeah, I may be given another 3 weeks time to file affidavit.
Okay. Mr. S. Kapil, senior governor advocate. The press for and is granted 3 weeks time to file counter affidavit. This is after 3 weeks. Number 5.
Here, Lordship, I have a similar pair, Lordship. Up to item number 8, Lordship. All are analogous matters, Lord.
5, 6, 7, 8.
Up to 8.
Lordship.
Oblige.
Item number 9.
No. Yeah, Lordship, we have already complied the Lordship judgment passed by Tribunal Court, Lordship.
What is the
Kindly see the judgment. Judgment is at page, Lordship, page 21, Lordship.
yes. What was the direction?
Lordship, direction was to Lordship, threefold directions are there, Lordship. If petitioners have been Lordship appointed against the sanctioned post, then benefit of para 53 of the Uma Devi case may be given to them, Lordship. This is the one full direction, Lordship. And
Now, sorry, Miller, I was under the impression that this is a different item. So suddenly I confirmed from my brother it is item which I am supposed to appear.
We are hearing the respondent.
Oh,
This is a contempt case.
yes, brother. There is service upon the newly impleted respondent has been completed. And
No, he says that the order has been complied with.
no, below
Captain is trying to show this court that the order has been complied with.
no, Milord, it is not. In that case, let me start my argument first.
Okay.
Milord, kindly come to page 40.
Page
40.
40.
Page number 35. That is the operative portion of this order,
Yes.
12 and 13. Page 35, Milord. As we have not determined, the contention raised both by Mr. Gogoi, learned counsel for the appellants, and Mr. S. Tapin, learned senior government advocate, as to whether the appellants are working against any sanctioned post. The respondent authorities in the Department of Power may examine the claim of the individual appellants and determine as to whether any of them are working against any sanctioned vacant post, and whether they have worked for a period of 10 years or more up to 10 for 2006, that is Uma Devi. And without the aid of any court order, if all three conditions are satisfied, we are of the view that provisions of paragraph 53 of the pronouncement of the Supreme Court in Uma Devi Supra would be applicable, and the relief of regularization be entitled accordingly. Now, para 13, next. On the other hand, if upon verification, it is found that any such appellants are not working against any sanctioned posts, but are in employment and performing work of similar nature, quality and quantity as that of an equivalent regular employee, the relief of providing wages equal to the salary at the lowest grade of employees of their cadre be provided to such appellants. Further, if upon examining
What is the ultimate direction? These are appears to be nature of a guidelines. to be followed by the administration.
Now the question is,
If, yes, what is ultimately the direction? You have been directed to regularize.
regularize.
What is that? Let us come to that.
Now, let me come to that point. Now what they have done is to overturn the direction of this honorable court.
No, let us first understand what is the direction of this court.
The direction of this court,
Yes.
there's twofold. The first is if any of these applicants.
Yes, from the record,
Yes, I'm on the page 35 only, my lord. I just
Yes.
explained from here.
because I can see many paragraphs are there up to page 40.
Twofold directions were there. The first direction was if this applicants, if they have worked for more than 10 years before the authoritative pronouncement of Uma Devi,
In a
then they
sanction
should be,
post, without the aid of the court, they should be regularized.
pardon, my lord?
If they had worked for 10 years in a
Yes.
sanctioned post, without the aid of the court's order, they should be regularized. Is that the direction?
To determine whether they are working against, kindly come to this, to para 12.
Yes.
Line third will be
Para 12 is the ultimate direction of this court.
12 and 30.
Okay.
What it says, my lord, the respondent authority, line third I'm reading, my lord. The respondent authorities in the Department of Power may examine the claim of the individual appellants and
All right,
determine as to whether any of them working against any sanctioned post.
all right, all right.
vacant-
That you have read out.
Yes.
So your allegation is that determination has not been done.
Not been done.
Okay.
And the second direction is
Okay.
if they are not getting the salary
Hmm.
at par with the regular employee, there cannot be discrimination and you should give them the equivalent salary. my lord.
Where is that part?
That is para 13.
Hmm?
Para 13, next page,
Para 13 on the-
36. On the other hand, if upon verification, it is found that any such appellants are not working against any sanctioned vacant post, but are in employment and performing work of similar nature, quality and quantity, as that of an equivalent regular employee, the relief of providing wages equal to the salary at the lowest grade of employees of their cadre be provided to such appellants. Further, if upon examining the individual cases, the department finds that any of the appellants are in employment but are not performing the similar nature, quality and quantity of work as that of an equivalent regular employee, the other relief provided in the judgment dated 17/01/2017 for an adequate financial package be provided to such appellants. The twofold directions were there. So now the question is, instead of doing those particular exercises, the department have constituted a committee and overturned the decision of this honorable court.
What is the other relief provided in the judgment dated 17/1/2017 for an adequate financial package be provided to such? What is the judgment dated 17/1/2017?
I apologize. I have only got the contempt petition today. Well, first, accommodate me after 1 week.
Thoughtful direction lawsuit.
Hmm?
This is a judgment of
Which, where it is?
482 of the 11 lawsuit. Here
In
lawsuit,
your
the
affidavit?
thoughtful direction is. Thirdly, if any such petitioner upon the determination is found that they are not performing the said nature, quality and quantity of works as being performed by the corresponding regular employees, an appropriate and upgraded financial package be formulated for such employees, commensurating the nature, quality, quantity of work performed by them. And such financial package should not give the impression that the exploitative enslavement against such employees are still being perpetrated.
No, where are you reading?
This is lawsuit judgment which has not been annexed in the contempt petition lawsuit.
My lord,
This because so far the third pole direction is concerned lawsuit. The judgment passed by this honor court.
just 1 second. my lord, kindly have indulgence
No.
to paragraph 3 of their counter affidavit, my lord.
We have found that in between, you are trying to make a submission that you have just received a copy of the contempt.
No,
petition. That's what
at least
You
not
seem
like-
to be adequately not prepared and you seem to be seeking some time also. Let us be clear. Are
No.
you ready with the case or to
No, that's why, my lord, I'm only
Okay.
seeking kind indulgence of my lord to paragraph 3 of their affidavit.
All right, we are going ahead with the hearing.
No. Only for one purpose, let them provide me that copy, my lord.
Which copy?
They said that the department also begs to submit that the Department of Power, Government of Arunachal Pradesh, Itanagar, in compliance with the order dated 30/11/2021, passed in read appeal number so and so
You
by
are,
this honorable
you are
court.
now in the affidavit filed by the respondent.
No, only for one, yes. By this honorable court had constituted a 4 members fact finding committee headed by the SE, SOPSO Itanagar
Yes,
SCM.
that is to be done.
Fact finding committee, son.
Lordship,
I want this fact finding
What
committee
he is
report.
asking?
in compliance of this direction, Lordship, a fact finding committee was constituted
Ah,
and they have made a report, Lordship.
okay,
I want that
On
copy.
report, we have examined, Lordship, and
okay.
we pass an appropriate order in compliance of the direction issued by this honorable court, Lordship.
Hmm.
And that has been annexed we have in
What?
our affidavit, Lordship.
That is annexed in the affidavit.
Lordship,
No.
we have annexed.
They have not,
Copy of the committee, report of the committee.
A report of the acting on report on of the committee, Lordship, the government has taken decision in compliance of order passed by this honorable court, Lordship.
Okay.
That order has been annexed in the
Report of the committee has not been annexed.
That has
not
not
been,
been annexed.
but only to that extent.
Perhaps he
But
wants-
we have discussed, the authority has discussed the report, Lordship, and then a decision has been taken, Lordship.
No, will not kindly request directly.
Otherwise,
government
report
counsel
And,
to keep it.
what the committee has found,
Lordship,
these.
here, Lordship, three-fold direction.
applicants, the first direction applicants have been working in a sanction post for the past 10 years.
So far that part is concerned, Lordship.
Ah.
Finding is that, Lordship, they were not appointed against the sanction post. Lordship.
Okay.
And second pole direction, regarding that, Lordship, the finding is that, Lordship, the nature and quantity of the works performed by the casual workers and the regular employees, Lordship, they are different, Lordship.
Hmm.
So therefore, they are not entitled for the lowest scale as in past in the Jagdish Singh's case, Lordship.
Okay.
And thirdly, Lordship, so far, Lordship, enhancement of this scale is concerned, Lordship, for casual workers, Lordship.
Hmm.
That, Lordship, kindly see the
Just, who are these petitioners?
casual workers.
Which
uh,
department? Which
of
department?
Power department.
Power
Lordship.
department.
Power department.
My lord,
And so far enhancement is concerned, if Lordship see the page 9 of my affidavit, Lordship, 29/5/2023, Lordship, this year,
Okay.
this May,
okay.
Lordship, some enhancement has been made by the government. So, in terms of all this action, Lordship, we have complied the order of this whole court
You better file that report
report, Lordship.
by way of an additional affidavit.
Correct, my lord. That fact finding committee report.
Because one fact which we don't find it to be entirely correct is the differentiation of the nature of the work between casual and the regular.
Regular employee.
See, every day you observe, these casual, they are the real person who are on the ground working. They may be working more than the regular.
Driving force.
So we are not commenting anything on
Yes,
that,
yes.
but you file it on the court.
Yeah,
To some extent, Lordship's observations.
Yes,
But basically, Lordship, as a regular employment loss, regular engagement Lordship, the person who is engaged in a particular trade, basically they are engaged in a particular trade, Lordship. So for casual is concerned, Lordship, they are engaged in that trade and sometimes the trade is changed, Lordship. As per requirement, Lordship, they used to be shifted from this trade to this another trade, Lordship.
okay.
So
Anyway,
that is the principle.
anyway, we need that fact finding committee report.
Which is that,
That paragraph 3 they have written in their affidavit. No, I've given it to you. This is, this is by
affidavit by whom? I don't find any.
four,
affidavit.
four. containment number 4.
Then Lordship, we may be given time to file our.
Sure.
Just.
By way of petitioner.
Who is this containment number 4? Let's find out.
There are 3 or 4 there.
This is, my lord, the affidavit dated. Joram Lali. He is one executor. Well, I want to point out one deficiency in this government advocate. Always we find, they never mentions the date on which they have filed this affidavit. They always leave it blank, my lord.
It is not mentioned in the service copy. It seems.
No, but then,
Anyway, sorry for that. Lordship.
No, but you should mention.
Yes, I'm sorry. I'm sorry.
affidavit is affidavit, my lord.
Just look at the evidence.
My lord, I provide it.
No.
These things not happen with the government affidavits only, Lordship. This council also they are doing this same thing.
Okay. Normally, my chamber doesn't do that. I used to guide my youngers, please don't suppress any fact or any date.
And to understand the third pole direction, Lordship, we need to bring on record the Lordship judgment dated 17/1 today is 17.
Also believe that only.
Because
That also,
since that has not annexed, Lordship.
Which, what judgment is that?
On the same power department, Lordship, same casual workers, Lordship. So under petition is another petition.
Who will bring it on record? You bring it on record.
He has to
I
bring
can-
it also.
No issue, Lordship.
Ah.
While filing the report, Lordship, along with that.
No, because after listening to my brother Tapin's submission, my lord, what it comes to my mind is the intelligible differential. You are using the service of these poor people, and then you are making an intelligible differential. Using the negative equality
It is
concept.
not in my record. Where is? It is in the record of my. Oh, just a moment. You have to bring on record what?
That fact finding committee report.
Judgment dated, Lordship, 17/1 today is
First is the fact finding.
Fact finding report.
Fact finding committee report on 3rd February 2023. Which judgment? Tapin, this is which paragraph? 36.
Wait, नहीं already हो जाएगा
On the prayer of
नहीं
this.
डालेगा यहीं डाल देगा
Yes, Tapin, council for which respondent?
Four.
Lordship, I'm for
You are for the 4th.
Respondent number 4,
2 to 7, Lordship.
2 to 7,
2 to 7.
2 to 7. And all the respondents have filed affidavit.
No, Lordship.
Newly
The
imputed.
respondent, the same thing only.
Only
Lordship.
four.
We'll be relying on the affidavit.
4 will suffice.
Yeah, suffice.
Had Mr. You like the had Mr. Mr. L. Perme, council correspondent number 1, and Mr. S. Tapin for respondent 2 to 7.
2 to 7.
My lord, in contempt case, both of them are representing in the private capacity. Not as a-
Yes.
Needless to say.
Yes.
My lord, most of the time there is a confusion.
No,
Because-
we are also aware of certain things. Though affidavit in opposition is indicated to have been filed by the respondent number 4 in the office note dated 28/6/2023. A copy of this said affidavit in opposition has not been placed on record in the first copy of the the contempt case, where is the said affidavit filed by the respondent number 4 has been placed on record in the second copy of the court's record. In view of the above, the registry shall do the needful to place on record the affidavit filed by the respondent number 4 in the first copy of the court's record as well. As prayed for by Mr. Tapin, learned counsel for the respondent number 6 to 2 to 7. 2 weeks, 3 weeks,
2 weeks.
2 weeks time is granted to file an additional affidavit by the respondent number 4,
Lawsuit.
respondent number 4, to bring on record the fact-finding committee report
3/2/2023.
dated 3/2/2023,
3, yes.
as well as
This order dated 17/01/2017.
order dated 17/1/2017,
2017.
passed in WPC.
This order, Milord, exactly,
17/1/2017
no, no, passed in which?
No, that is the date. Passed in which writ petition?
480.
482. Milord. 482. Yes.
482 of
AP 2011.
482 AP 2011.
11.
Okay. Listed after 3 weeks.
3 weeks. Grateful.
You have put a petitioner,
No, madam.
private respondent.
I have not been supplied here, a copy of the petition.
You want to file objection, means you want to file counter affidavit.
Counter affidavit, I did a copy.
You have put respondent number 5.
Yes, that's one.
So how much time? What is the matter, Emma?
That is regarding this violation of DPI. I have executed some work, there is an allegation that DPI has been violated.
Okay. 2 weeks time. Good. Mr. P. Tapa, learned counsel for the respondent number 5. Respondent is granted 2 weeks time to file counter affidavit. Listed after 3 weeks. Have you filed affidavit?
Your Lordship, we have received our Paravas reply. So we too need some time, Your Lordship. 2 weeks.
Okay, you
is
also
okay?
file within 2 weeks.
Yeah, okay, Your Lordship.
Had also Miss P. Pamela, Governor who submits that he has received instruction to file counter affidavit, for which he also pressed for and is granted 2 weeks time. Did you say earlier 3 weeks? Did you say 2? This is after 3 weeks.
Yes, Your Lordship.
केस लोग बोल दिया ना
आइटम नहीं आप बुलाया था क्या? आइटम नहीं बुलाया था क्या? हाँ हम सुनाई नहीं दिया, हम सामने में आवाज कम हो गया होगा। हम तभी ना कर रहे हैं।
काम खत्म हो गया तो बोलेगा नहीं
Yes. वो करें ये तो पूरा है जो यही शेयर करेंगे woman comedian
मतलब मैं mention item number मतलब 6 item number 6 मतलब This is basically listed for the admission hearing, my lord. In the meantime, my lord, the respondent Union of India, my lord, instructed me to, my lord, take the reports of my adjournment, my lord, time. My lord, matter is under active consideration between the Deputy Commissioner and the, my lord, the Union of India, my lord. This is regarding, my lord, compensations in respect of past position, my lord. Present position we have already paid. Now it has to be decided for the past position, my lord.
Okay.
3 weeks time will be granted, my lord. I've taken the consent of
Any
the
objection? Okay. I speak to the Mr. Kato and council, then the DSGO, no?
Mine.
List it up to 4 weeks.
Mention, madam.
Yes,
Deputy Ombudsman.
Well, I beg to mention item 1, 2, 3, and 4, madam.
1, 2, 3, and 4.
My lord.
In this matter, the learned Advocate General is appearing. Has put across a message that learned AG is appearing against me.
He is brave, my lord, to fix the matter on 8, my lord, 8 of August, my lord, 8, my lord.
8 of August. What is this matter about?
Well, my lord, we recall that the petitioner was the district veterinary officer. And then he was appointed as managing director of the Arunachal Milk Union, a society registered under 1860, or section 9 of the Cooperative Society Registration Act. Now the departmental proceeding has been initiated for performing his duty in the Arunachal Pradesh Milk Union. So what we have projected in this case is for performing duty in the non-registered registered organization, disciplinary inquiry has been initiated against me and I have been suspended.
All right, all right. Why AG's appearance has been sought in this case?
I don't know.
My lord, department has requested his service, my lord, in this case, my lord. Department has requested his service, my lord. Some legal,
Okay.
some legal issue involved, my lord.
What kind of legal issue?
Legal issue, my lord, in the case projected with a petitioner, my lord, whether, my lord, the appointing authority, my lord, can initiate departmental inquiry against the officer, my lord, related to his duty in a non-government organization, my lord. Some legal issue will be involved.
Rule 15 of CCS rule is very clear.
After 15 August?
My lord, yes, my lord, he requests me, my lord, he is coming, his case on 7 also, my lord, on 8 also, my lord. They are
He is not supposed to come. He is supposed to be here. He is the Advocate General of the state.
truly, my lord, true, my lord.
When
My humble submission would be, my lord, let my lord matter be pitched on 8, my lord, and after
okay.
that,
8 August.
Eight.
No problem.
On the prayer of help from him and the council for you have for respondent.
yes, my lord.
Which respondent?
Is
All respondents.
all is the
Okay,
response.
for the state respondent listed on 8th of August. Okay.
Obviously,
1 to 4, no?
1 to 4, my lord.
All right.
May I please, your lordship?
Yes,
I beg to mention item 8, lordship.
8.
Yes, 8. Lordship, in this case, during the pendency of this petition, some other order has been passed, due to which the petitioner has to take a call whether or not to continue with the case or to file another case. So we need some time. 3 weeks time may be given, lordship.
Okay, on the prayer of Ms. M. Dangan, on the council for the petitioner, listed after 3 weeks.
3 weeks, lordship. All right.
My lordship,
Yes,
lordship, I'd like to mention item number 16.
16.
Yes, lordship. This is a matter of RTI matter pertaining to quashing of the MP order.
16,
Lordship, 15.
15.
Lordship.
Yes. What do you want?
The leading counsel is not today, so due
Okay.
to some medical ground.
On the prayer of Mr.
And Pada,
You are not Enpada.
no, Lord.
What is your name?
Jay Saro,
J. Sara.
Lordship.
Council on behalf of Mr. Enpada, on the council for the petitioner, listed after 4 weeks.
Lordship, and and there will be a interim order.
What is Saikia? Have you informed the other side?
We have taken the consent.
Okay. Interim order plus, then you write with the consent of our Saikia. On the descending council for the APIC listed after 4 weeks. Interim order plus, will continue till the next day to listing. Okay.
Obliged.
I've taken notes. Item 23 and 24.
23 and 24. Yes,
I have been instructed to withdraw this matter.
withdraw this matter. Your good name?
Yes, my lord.
Your name?
He mostly.
T. Motu,
Mosu.
Mosu, M-O-S-U.
Yes.
Your name is not there in the cause list. Okay. All right, anyway, no issue.
Yeah.
You want to withdraw this petition?
Yes.
Because it has become infructuous.
Yes.
Okay. Mr. T. Mosu,
Yes.
learned counsel for the petitioner. And you are a petitioner in both the case.
Yes.
And
Both the
Miss-
petitioners have been
and
required.
Mr. T. Tagum, learned standing counsel for the health department. Mr. Mosu submits that these writ petitions have become infructuous. And therefore would like to. Just infructuous. As submitted by Mr. Mosu on the council petition, writ petition is still dismissed as infructuous. Interim order.
Yes, no.
Okay, yeah, all right.
May Lordship.
Hmm.
I beg to mention item number 25.
Yes,
My senior counsel is out of station, so he could not appear today. And kindly this matter may be adjourned for today.
M13.
Yes.
What is this matter about?
This matter is about the termination of service of the petitioner without any opportunity of by respondent
Okay.
authority. I have
On
taken the consent from the opposition.
How Miss
Dirilo.
D. Rilu, learned counsel, who press for an adjournment of this case by 4 weeks,
3 weeks.
3 weeks. Okay, on the prayer of Ms. D. Rilu, learned counsel for the petition, please sit after 3 weeks.
Much obliged.
Madam, I beg to mention item number 7, madam.
Hmm.
Madam, I may be allowed to withdraw this matter, madam.
Huh? You may be
Allowed to withdraw the matter, madam.
become in process.
Yes, madam.
Mr. Marge D. Learned counsel for the petition, submits the writ petition has become in process. Some as in this. As in view of the above, writ petition stands dismissed as in process. Interim order pass earlier is, if any, stands vacated.
All right.
May I, Lordship? Lordship, I beg to mention item number 17. 17.
117, yes.
This matter may be listed after this Monday, the coming Monday.
Coming Monday.
Yes.
What is the matter about?
Discharging of constituents from.
I'm here to petitioner matter. On that occasion, my lord,
You come to the mic. Who is for the petitioner?
I'm for the petitioner.
Okay, you,
So,
yes.
my lord, on last occasion, my lord, on the request of on the prayer of Mr. Tirijamo, last chance was granted, my lord, for filing affidavit. 3 weeks, 2 weeks, time was granted last time, my lord.
All right, you wait, we'll see when the matter is called up.
Your Lordship, with the consent of other parties, I, on behalf of Ms. Senior Counsel A. Apang, would beg to mention item number 5.
Yes. Okay. What kind of a mention you would like to make?
Since the APPSC commission is yet to be constituted, so any order passed in this matter would be difficult to execute. Therefore,
Yes, Tagum.
This is regarding for matters to be considered by the PCS manner.
PWD
Yes, PWD candidate manner.
listed after 8 weeks.
Yesterday, my lord, investigation. 4 weeks.
4 weeks? No,
But
what?
I heard from that yesterday, some like maybe cabinet structure, but I don't know.
That criteria under PW Act has been reduced of giving grace mark of 5 to some 6 marks. cabinet has taken a decision yesterday.
No, what he is submitting is the, even if the writ petition is allowed in this writ petition, it is the APPSC who will have to take a decision in the matter. APPSC is not constituted. That
Yes,
is why this matter may be adjourned.
my lord,
So,
one APCS, my lord, that is commissioner, the matter related for the member, my lord, is fixed on 8th of August, 7 and 8, my lord. So in that case, my lord, it will release after 4 weeks, my lord.
4 weeks.
Yes, sir.
I
Okay.
think correct.
On the prayer of the council for the parties, list after 4 weeks.
My lord.
My lordship, this is regarding this conduction of the student election in NIT lordship. Lordship, National Institute of Technology Arunachal Pradesh is 31 National Institute of Technology in India lordship and established in 2010. Lordship, phase number 23.
Page number 23.
Yes, lordship, that as for Lendo committee, that direction has been given by Supreme Court, that as for decision of the Supreme Court, lordship, page number 25 is direction given by Honorable Supreme Court of India. Lordship. Page number 25.
Yes.
Yes, lordship, the recommendation of committee accepted by Honorable Supreme Court for implementation, lordship, that university and college across the country must ordinarily conduct election for appointment of student through student representative bodies. This election may be conducted in manner prescribed herein or in the manner that conform to the standard prescribed herein. Lordship, this is a rules and regulation regarding election of the student in university and college. And as for this direction, this is mandatory, lordship. And in this regard, student had submitted many representation, lordship. And following this representation, the authority of NIT come up with one decision, lordship, page number 39. Lordship, this is minute of the 44 meeting, Board of the Governor, National Institute of Technology, Arunachal Pradesh. And as for this decision, page number 21 is decision, 41. Student of NIT Arunachal Pradesh has submitted an application on 8/9/2022 seeking permission to form a student body at NIT Arunachal Pradesh in the name of Student Union of the National Institute of Technology Arunachal Pradesh. Matter is placed before BOG for the discussion and decision. A complaint was received from the student of NIT Arunachal Pradesh regarding threatening to Mr. Lika Gonu, a PhD scholar by some outsider, on the matter of formation of student association by NIT Arunachal Pradesh student. Matter is placed before the BOG regarding sensibility of the issue for discussion and suggestion to prevent occurrence of similar incident in future. BOG discussed on the matter and observed that existence of student union in NIT system is not mentioned in NITSAR Act and Statute. Moreover, NIT being an institute of the national importance with national representation in student community, it is expected that they should concentrate more on their study and research. As such, BOG opined that the present demand for student of the constitution of the student union in NIT Arunachal Pradesh is not acceptable. BOG noted the threatening of the NIT student by outsider inside the institute campus is a serious issue. BOG also advised to constitute security advisory committee with local senior police official as its member for advice regarding elaborate and effective security arrangement within the campus immediately. Lordship, this is just because that some outsider has created some disturbance, Lordship. This cannot be ruled out mandatory decision and judgment of the Supreme Court, Lordship. And Lordship, having this decision authority of the NIT is
Yes.
not conducting, Lordship.
Hmm?
And Lordship, my prayer is direction to the NIT for conduction of this student election as per the Supreme Court of India, Lordship. Decision of the Supreme Court of India, Lordship.
Which is that decision?
Lordship, this is Lordship, page number 23. Back to the page number 23.
23.
Yes, Lordship. Lordship, this is Government of India, Minister of Human Resource Development, Department of Higher and Technology notice, Lordship. As per notice, Lordship, they have Lordship annexed and mentioned the decision of the Supreme Court, Lordship.
Which is the decision? Do you have the decision with you?
Lordship, decision, this is just a notification from the Government of India.
That I have seen.
Yes, wherein it has.
Here it talks about some decision of the Supreme Court. Do you have the decision with you?
Yes, Lordship, in
Okay,
government.
let us hear this.
It's matter 2006-8 SSC.
Is it mandatory?
It's mandatory but subject to the association or the union, my lord. And for the purpose of my lord is given in the my lord, paragraph my lord 6.10, my lord. May I just read, my lord? Association only to the context of my lord for improvement of my lord, educational activities, my lord, educational purpose and sports activities, my lord. May I read, my lord? Just
Yes.
the student representation is essential to the overall development of the students, and therefore it is recommended that the university institutes should expressly provide for student representation. Student representation should be regulated by institute, either central institute, state institute, individual university institute, incorporating recommendation prescribed therein. Institutes should organize leadership training program with the help of professional organizations so as to groom and instill student leadership qualities, my lord. My lord, this is the mandatory direction, my lord. In fact, my lord, what he has not annexed in this writ petition, my lord, pursuant to their representation, my lord, lordship will find at page 28, my lord. My lord, page 37, my lord. Only first page is been annexed, my lord. A request has been made by the students, my lord, for page 37, my lord.
Yes.
8/9/2022, requesting for formation of student body union association at NIT AP Jote, my lord. My lord, pursuant to that, my lord, this, my lord, the NIT has issued a notification, my lord. My lord, may kindly peruse for a moment, my lord. These are not annexed in the writ petition, my lord. By this notification, my lord, on 21/10/2022, my lord, a student body has been, my lord, constituted by the NIT, my lord. May I read, my lord? This is notified for information for all concerned that there shall be Students Association of NIT Arunachal Pradesh under the provisions given below, which are subject to amendments for the evaluation of the assessment. Aims. The aim of Students Association NIT is to work for all-round welfare and development of the students and NIT Arunachal Pradesh as non-profit making organization. Objectives, my lord. Association shall be representative of all the students of NITP. The association will be a channel of communication between the student community and the director, registrar, dean, HOD, chief, warden, sports officer, security officer, health officer, etc. My lord. Purely, my lord, this organization has been, my lord, notified for the overall development of the students, my lord, in regards to the education and the sports, my lord. And my lord, pursuant to this, my lord, notification, my lord, in fact, my lord, election were also held, my lord. Elections were held and the president, chairman, president, secretary, all were elected, my lord. Elected, my lord. Which can be evident also from, I don't have that, my lord, report, my lord. But, my lord, this can be evident from the page 38 representation, my lord. Kindly see, my lord. With due humble submission, we'd like to inform you that new executive student of body of NIAP is elected as per election notification, such and such, such and such, such and such, my lord. Now, my lord,
Okay, we would like to interview the new of the student elected as well. Okay, who are they?
names are not given, my lord, but the students of the my lord.
Do you have the particulars?
No, my lord.
Is there any students union now?
Yeah, Lordship, this, there, yes, student of the NIT, Lordship,
A student of the
NIT,
NIT?
yes, National Institute of Technology, Arunachal Pradesh, Lordship, petitioner.
No. Is there a NIT students union?
Now, Lordship, now, at present, no student union, Lordship, because decision has already taken by authority, wherein that it is as per the decision that student union is not acceptable, Lordship. This is mentioned.
What happened
since-
exactly, my lord? I'll file in detail affidavit, my lord. This, my lord, association has been notified by the institute, my lord. Now, what they want that, my lord, they are not, my lord, interested with these objectives of the, my lord, association, my lord. And they further requested, my lord, the director and the registrar that their union activities should, my lord, expand beyond these objectives, my lord.
Okay.
That's why, my lord, the matter was placed before the BOD and BOD has rejected those proposals, my lord.
No.
And
Lordship,
my lord, they want the union at par with the, my lord, student union such as, my lord, APSU, ANSU, my lord, like that, my lord. That was not acceptable to the, my lord,
No.
the authority, my lord. That's why, my lord, that was rejected, my lord. My lord, kindly see, my lord, the board of,
So
we'll
better-
file, my lord, detailed affidavit.
Better at this stage, we issue notice.
Yes,
Yes,
yes, yes,
sir.
my lord. And my lord, also, my lord, this institute, my lord, is within the, my lord, is governed by the Ministry of, my lord, Education, my lord, Government of India, my lord. And the ministry is not being represented by the, in this writ petition, my lord. Because, my lord, we are being functioned by the, my lord, act of the, my lord,
Okay.
Government of India, my lord.
Anyway, we'll see. G Gato for petitioner, I'll say for R1 2. Notice 4 weeks, extra copy.
obliged, Lordship.
Yeah, please. Lordship. Lordship, basically, this is a petition challenging the transfer order, which has been passed against the petitioner. Lordship.
What is the order?
Lordship. Lordship, this, the petitioner is presently posted as a DBO at Paki Kesang. And he was posted at this place in 1 year, 7 months back. Lordship. Now, after that, the 1 year, 7 months, prematurely he has been transferred to Colorian, Lordship. Now, the petitioner is in the verge of his retirement. So after 1 year and 4 months, his retirement is due, Lordship. So prior to the joining the Paki Kesang, Lordship, the petitioner has already served 4 years at one of the remotest place of the state, that is Anjao, Lordship.
Please show us the impugn transfer order, where it is.
Lordship,
And you have been transferred from where to where? Pakistan to where?
Colorian, Lordship.
Coloria.
Yes, Lordship. Lordship, may kindly come to page number 13, Lordship. This is the,
13 is the impugn order.
yes, Lordship. Lordship, my retirement is also due in the next September 20 2024 Lordship. Lordship, as per the guidelines, a person has to be at least served 2 years in the posting place, Lordship.
You are
Lordship, I am
Sinha.
Dr. S.K. Sinha, A.K. Sinha.
8 years with Pakistan. What is the ground of challenge?
Lordship,
You-
I have been,
You have not completed 2 years.
yes, Your Lordship. Moreover, Lordship, my retirement is also due after almost a year, Lordship.
When?
Lordship, September 24, Lordship. Lordship, I have been transferred on the behest of some politician only to accommodate the respondent number 3, private respondent number 3.
Which respondent?
Respondent number 3, Lordship.
Respondent number 3.
Lordship is Dr.
No. Which respondent is the political person?
Lordship, that is not been one of the local MLA as I have been
Have you
told by
filed
the,
any representation?
yes, Lordship.
Where?
Lordship, may page number, Lordship,
Where is the guideline, transfer and posting guideline?
Lordship may kindly come to page number 16, Lordship.
16.
Yes, Lordship. May I read the Lordship? In the partial modification of this office, circular part number so and so dated 2nd June 1998 regarding the policy guidelines on transfer and posting of all the categories of officer and staff in Arunachal Pradesh.
Okay, all right. We will not interfere. Where is the representation?
Lordship, page number 17, next page.
17.
Yes, Lordship.
Okay. 9 June. Not been disposed of.
Not yet, Lordship.
Had Mr. D. Sakia,
Yes, Lordship.
counsel for the petitioner, and Mr. L. Corwin, learned counsel, extending counsel for the animal husbandry and veterinary. Representing respondent 1 and 2.
2 million, 1 and 2.
Only 2.
1 and 2 million.
1 and 2. This petition is directed against the order of transfer dated 29 May 2023 issued by the Commissioner ASB, Governor Honorable by number so and so, page 13, whereby the petitioner, who is, what are you? Who is
DVO, Lordship.
district
Veterinary
Animal-
office.
District Animal Husbandry Veterinary Officer, Parking Kesam, and now has been transferred and posted as DVO Kurunkure, and in his place, the respondent number 3, who is, respondent number 3 is also a DVO.
Yes, Lordship.
Not DVO, who is also an animal husbandry and veterinary officer working at Longling, has been brought in. Full stop. The challenge made to the opposite order of transfer dated 29 May 2023 is that the petitioner has completed only 1 year and 7 months of posting at Parking Kesa, whereas the transfer and posting guidelines dated 19 December 2008 issued by the Chief Secretary, Government of Municipal by number so and so at page 16 provides for posting of a particular employee at a place for 2 years. Full stop. Accordingly, the petitioner contends that he has been transferred prematurely before completion of the 2 years of the posting. Also, since it is a well settled position of law that before that, apart from the above grounds taken in assailing the impugn order of transfer dated 29 May 2023 in sober as the petitioner respondent is concerned. The petitioner has not us any other grounds such as a manifest exercise of power by the respondent authorities in issuing the impugn transfer order. Also, since it is a settled position of law that though the transfer and posting guidelines may prescribe a particular tenure of posting at a particular place, it is the prerogative of the employer to transfer an employee even before the normal tenure of posting is normal tenure of posting as per the guidelines. Even before the normal tenure of posting as per the guidelines. Okay, if it is completed. Full stop. Completed for administrative exigency. Also. In that view of the matter, in the absence of any allegation against the respondent authorities of malafide exercise of power in issuing the impugn transfer order dated 29 May 2023 in sober as petitioner and the respondent number 3 is concerned, I am not inclined to interfere with the impugn order of transfer and order dated 29 May 2023. Full stop. The petitioner appears to have submitted a representation dated 9 June 2023 to the Commissioner AHB and DD, Government of Arunachal Pradesh. What is DD? Okay, Dairy Development.
Yes, sir.
For retention of the petitioner at Pakekesam.
Yes.
Full stop. The respondent, the Commissioner AHB and DD, the respondent to one hearing shall consider and pass an appropriate order on the representation submitted by the petitioner dated 9 June 2023 within a period of 2 weeks from the date of receipt of a certified copy of the
Representation
order.
date is 3/7/23. Date of representation is 3/7/23.
Page number?
Page number 17.
17 in my record, it is 9 June 2023.
Lawsuit fees. Correct.
Huh?
Yes, sir.
You should dispose of with the above. In terms of.
My prisoner.
Oh.
I'm challenging the impugn transfer order dated 13/7/2023, my lord. My lord, you'll find the impugn transfer order at page number 18, my lord.
Yes,
My lord, I am at serial number 6, my lord.
yes.
Kasim ADCF. I was transferred from DFO Pasigat Forest Division to and attached to the office of the CCF EAC Teju, my lord.
Yes.
My lord, on page 20, my lord, 20. On 14th July 2023, my lord, I filed a representation, my lord, for retaining me at Pasigan, my lord. The reasons being, my lord, I'm only 8 months is left, my lord, for my superannuation, my lord. And this transfer order, my lord, it is totally in violation of the circular dated 2 June 1998, my lord, wherein it has been clearly provided that a person should not be
transferred if he is superannuating in 1 year, my lord. My lord, may I find the circular, the next page, my lord. 21. The award copy is at page 24, my lord.
Page 24.
Yes, the award copy, my lord. I'm concerned with D, my lord. Clause D, my lord. Officers are not to be transferred 1 year before retirement as it may affect preparation of their pension papers, etc. However, generally, officer posted in field work division should be posted out to the office headquarters 1 year before retirement, my lord.
You have been posted to headquarters.
No, my lord, I was posted at Pasigat, yes, my lord. Now I have been transferred and attached to the CCF office, Teju, my lord.
Yeah,
No.
which is the headquarters?
Now, my lord, can you turn to page 28, my lord?
28.
8. Yes, my lord. Serial number 1, my lord. I joined the service on 7/7/1984, my lord.
Serial number 1.
Yes, my lord. The next column, my lord. 7/7/1984. I joined the service, my lord. And I'm returning on
64.
84, my lord. 64 is my date of birth, my lord.
You are retiring in the March.
Yes, my lord. 31st of March 2024, my lord. So only 8 months are left, my lord. Therefore, my lord, may I humbly pray, my lord, this impugn transfer order is totally illegal, my lord. And in violation of the circular dated June to 1998, my lord. Please, my only grievances, my lord. My lord, I have put in all 59 years of my service, my lord. And I don't have any blemish, my lord. I've been serving the department, my lord, with my utmost effort, my lord. And on the verge of retirement, my lord, I put in almost
Yes.
36 years, my lord.
Yes, Ratan.
I appear for 1 and 2, my lord. Representation submitted
Yes, my lord.
can be disclosed.
Where it is?
My lord, representation, my lord, will find at page 20, my lord.
Page
20.
20.
14 July 2023, my lord.
You have been released.
No, my lord. I have not been released, my lord, and my reliever has also not come, my lord.
Mr. O. Parel on the counsel for the petitioner. Mr. N. Ratan on the ALG for R1 and 2. This petition is directed against the order dated 13 July 2023 passed by the PCCF EFNCC at base 18 by number so and so, whereby the petitioner, who is a DFO Pasigat Forest Division, has been transferred to Teju in the office of the CCF. What is EAC?
I'm not aware of it, my lord. Yes, I'm not aware, my lord.
Okay, the office of the CCF,
CCF.
EAC, Teju. And in his place, respondent number 3, who is a DFO Nampong Forest Division, Jairampur, has been brought in. The case of the petitioner is that he is retiring from service on 4th March 2024.
31st of March.
Huh?
31st of March.
Why 31st of March? You were born on 5th March.
7th. Oh, no, yes, my lord. But then,
Your date of birth is 5th March.
yes, my lord.
So you should retire on 4th, I think.
But 31st, my lord, it has to be
31st March.
Yes, my lord. If
Yes,
it is
my
not
lord,
one, my
government
lord.
Servants, my lord,
Huh?
on the ending of the month.
Okay,
Yes,
31st March. Huh?
yes, my
Okay,
lord.
31st March 2024. Which is barely 10 months,
8 months, my lord.
8 months from now, and therefore the impugned order of transfer is in violation of the transfer and policy guideline issued. The transfer policy guideline dated 2nd June
June 1998,
1998, issued by the
Department Personnel, my lord, Under Secretary Personnel.
the Department of Personnel. Where comma in clause 1D, it has been provided that officers are not to be transferred 1 year before retirement, as it may affect preparation of the pension papers, etc. Full stop. However, comma, generally officer posted in the field stroke work divisions should be posted out to office headquarters 1 year before retirement. Full stop. Now the counsel for the petition the further submits that agreed by the impugned transfer order dated at the impugned transfer order which has been issued in violation of the transfer and policy guidelines. The petitioner has submitted a representation dated 14 July 2023 to the PCCA, EF and CC, Government of Arunachal Pradesh, for retention of the petitioner in at Pasigat. Full stop. Upon hearing the learned counsel for the parties, I deem it appropriate to dispose of this writ petition with a direction to the petition to the respondent number 2. Respondent number 2 is principal secretary.
Yes, my lord.
Respondent number 1.
One, my lord. PCCF, my lord.
Represented by PCCF. PCCF can represent
Oh,
the state.
yes, since it's a forest department, my lord. That's why principal secretary has been very.
But you have not indicated as principal secretary.
No, my lord.
He himself is the principal secretary.
No, principal secretary, I have married respondent number 2, my lord.
2.
Yeah.
He should be represented, state should be represented by the principal secretary. Perhaps.
I'm extremely sorry for
And
that.
PCCF should. Respondent number 1, PCCF, within bracket E and F, this is ECC on Arunachal Pradesh, to consider and dispose of the representation dated 14 July 2023 submitted by the petitioner in accordance with law within a period of 2 weeks from the date of receipt of the certified copy of this order, which shall be submitted by the petitioner within a period of 1 week from today. Also. Till the representations dated 14 July 2020 submitted by the petitioner is disposed of by the respondent number 1. The respondent, the PCCF so and so. The status quo insofar as the transfer and posting of the petitioner and the respondent number 3 by order dated 13 July 2023 issued by PCCF etc. by number 760 shall be maintained.
My lord. Like,
Dispose of.
But I am challenging the legality and validity of the impugned order passed by the deputy commissioner in connections with the land dispute, assuming the jurisdiction of a civil court under 2013 Act. My lord. My lord will kindly come. And then before this, my lord, let me place the fact in a very precise manner, my lord. The father and the son had a dispute over the plot of land, and that particular plot of land was not distributed, being the family land. So thereafter, what had happened was there was a Kaba decision on 14/12/1987, and wherein it was held in favor of the petitioner. And thereafter, my lord, on 8/1/1988, the Kava decision affirmed the land parted to the petitioner by the father, and there was, since then, he was under peaceful occupation, my lord. So then what had happened was, my lord, the bone of contention started from here at page 31, my lord. That is on 12/6/2012, my lord, the additional Deputy Commissioner Khamba, my lord, have issued a circular for payment of the land measurement of the land to pay the compensations to the actual landowner for construction of a double lane BRTF road from Alo to Kaing, my lord. So then what had happened was on 27/12/2013, my lord, the ADC Khamba has passed this order, my lord, assuming that jurisdiction, my lord, for a movement, my lord, kindly come to page 32 to 37. 37 is the important page, my lord.
37.
37, my lord.
You appears to be challenging 2017 order.
Yes, my lord, that's, I'm placing the fact so that, because since I am praying for the interim order, my lord.
Interim order also.
Yes, my lord. Kindly come, my lord. This
Without the maintainability of the petition also, you have traveled to interim order.
I have a good case for maintainability, my lord.
All right.
Kindly come to page 37, my lord.
37, yes.
37, that is the operative portion of this particular order. A careful considerations and hearing in the case, it is seen that whatever the dispute sale of land happened before 2990 was joint property, not property distributed by name. The ownership of the property affected after 29/1990, that is after distribution of ancestral property through local body Kaba. Therefore, the Kaba decision 29/1990, the land given to Sri Modo Kampi falling between Sri Jumge Kampi and Karmo Noshi, measured for 115 feet, stands valid. Compensation amount for this part to be paid to Modo Kampi. Now, my lord, what had happened is, because this land was parted and it is way back settled in 1988, then after 24 years, the additional deputy commissioner on a purported Kaba decision where the petitioner was not made as a party, my lord. Then what had happened, my lord? Against this, there was an appeal preferred, my lord. Before this, my lord, just for a fiction of the law, my lord, under even in the 1894 Act or in the 2013 Lara Act, my lord, the additional deputy commissioner nor the deputy commissioner has a power to decide a title, my lord. Power to decide a title. In one of the matter, my lord, which I have argued in 2019, PK Pulu versus the state of AP, it has categorically been held by this honorable court that under these two acts, the additional deputy commissioner or the deputy commissioner cannot assume the jurisdiction of a civil court to decide the title unless or otherwise it is referred to the regular civil court for deciding the title, my lord. So, my lord, this is the first impugn order, my lord. Then appeal was filed, thereafter withdraw, then all those things, my lord, I'll not take them, my lord. One important fiction is here at page 48 and 49. Then the title suit were filed on the advice of a counsel. Then the learned chief judicial magistrate comes, senior division civil judge Alo has refused to interfere with the matter, saying on this particular facts, may not kindly come to page 48 for a moment. Type copy is page 48A, my lord. Paragraph 3, my lord.
Yes.
This title suit was filed by the plaintiff under section 5 and 6 of the Specific Relief Act 1963, praying for declaration of title, ownership, right and possession of Dago land located at Kamki Blaze, and for direction to the district collector, ADC Khamba, for payment of compensation amount against the acquired land of the plaintiff by the government, which was wrongly paid to the defendant. It appears to this court, without going into merit of the case at this stage, that the land in dispute has been dispossessed after passing of order dated so and so by ADC Khamba, West Siang, AP, for the purpose of construction of Trans-Arunachal Highway. In order to allow any suit under section 6 of the above Specific Relief Act 1963, plaintiff has to file the suit within 6 months from the date of dispossession as per section 2, subsection 2, subclause A of above act. But here, in this case, suit was filed only on so and so date for 11 months, due to which, apart from, kindly mark this particular paragraph, page 48A. Apart from this, as per section 74 of the right to fair transparency in the land compensation, acquisition and rehabilitation and Reinstatement 2013, any person aggrieved by the award passed by an authority under section 69 would file an appeal to the High Court. You know that within 60 days from the date of award. I understand the word in this section means including compensation amount against the land. In the circumstances above, the learned court below has not interfered with. Now, my lord, what had happened was, against this, my lord, there was a read petition filed, number 228, 2015, and these directions was there, and then on 5/10/2017, the impugn order was passed by the Deputy Commissioner Alo. This is under challenge at page 50 to 60. Kindly come. But my lord, before I indulge my lord to pay the impugn order, my lord, let me make it clear before this honorable court, my lord. So against that order, so as passed, my lord, the second appeal was filed. Appeal order application was filed before this honorable court on by invoking wrong provisions of the law. So therefore, my lord, there was a liberty granted, my lord, that order. My lord, then that SO, then my lord, what had happened there? Wait. Then, my lord, finally, the question of law was not framed, which is mandated under the provision of CPC. My lord, on 19/6/2023, the liberty was granted, my lord, to file a fresh application, my lord, 73 and 74, my lord, for a moment. My lord, kindly come to 74 for a moment. Mr. So-and-so, learned counsel for the appellant, prays that he may be allowed to withdraw the petition in view of settled position of law. Prayer is allowed. Accordingly, the second appeal against the order is permitted to be withdrawn with a liberty to file appropriate application if so advised, my lord. So here, my lord, there's the reason why, my lord, we have not filed delay condonation application, my lord. So within the limitation, my lord. Now coming back, my lord, to the impugn order at page 56, my lord.
Not coming back. Now coming to the impugn order.
I was in the last page, so now I am coming back.
Yes.
Anyway, my lord, let us, to err is a human, let us correct each other. My lord. 50, my lord, 50. No, this is not the one. 56, sorry, my lord. Well, this is here. The learned Deputy Commissioner has patently erred with the due process of law before upholding the decision of the additional Deputy Commissioner, my lord. in this context, my lord, the learned
The order title of the case is in the matter of land dispute case.
correct.
Ah,
But the provision is under land dispute would mean, my lord, that the lease involved was with regards to payment of the land compensation, my lord. So therefore,
so it is a civil dispute.
civil dispute.
Ah.
So therefore, the additional deputy commissioner and the deputy commissioner being an executive magistrate, my lord, neither in the CRPC, my lord, has a power to decide or can assume the jurisdiction of the civil court to decide a title. My lord, kindly come.
No, in 2017, Civil Courts Act had was okay. You are challenging the jurisdiction.
Yes, therefore, my lord, that compensation, let them take, no problem. But the future litigation, the future complications that would arise.
No, just what is the ground of challenge of the order at page 56?
Page 56 is that the other deputy commissioner, while affirming the order passed by additional deputy commissioner, is patently illegal for the reasons that they have not followed the due process of law.
But the deputy commissioner had a jurisdiction to pass wrong order.
No, my lord. So therefore, this is known
Okay,
as
you are not challenging the jurisdiction of the deputy commissioner.
well, patently, my lord, because whenever there is
See, patently illegal, but nevertheless, the deputy commissioner had the jurisdiction to pass order or not.
no, my lord.
Okay.
In the land compensation matter, my
See,
lord,
patently illegal is another aspect. That is quite different from contending that the deputy commissioner had no jurisdiction. Which is your case? Patently illegal or no jurisdiction?
no jurisdiction.
No jurisdiction.
No jurisdiction. And my lord, I place this authority, my lord.
No, before that authority, let us come. What was by this order, the ADC order has been upheld.
Upheld, my lord.
Okay.
At page
What was the order of the ADC?
ADC page 37, my lord. Very soon, it's like copy.
Yes. What is 37? In brief.
Yeah, just I'm coming. My lord, what had happened was here,
ADC had the jurisdiction or not?
no,
ADC also had not.
no jurisdiction under 2013
It is
or
a,
even
it is
18
a land dispute
land dispute.
between petitioner and which
It's a private respondent.
private respondent. ADC had decided the land in favor of whom?
The private respondent, my lord.
Private respondent, which has been upheld by
The deputy commissioner at
deputy
page
commissioner.
57.
In the year 2013 and 17, which was the court of competent court of civil jurisdiction to
No,
decide.
my lord, before that, the Assam, Agra, Bengal Civil Code Act was followed in Arunachal prior to 2011, my lord. So now, what had happened was, following the judgment of Brij Mohanlal case, my lord.
Have
Then-
you pleaded all those cases?
No, my lord, just
okay.
I'm supplementing on law, my lord. So what had happened in 2009 that Brij Mohanlal judgment came into, then the fast track court was constituted in Arunachal. And pursuant thereto, my lord, that 2013 for SSC page 1140, the Registrar General case, my lord. Then the judiciary and the executive was separated, my lord. Meaning thereby, my lord, all the cases earlier which were conferred to the executives in Arunachal to function in both the jurisdiction, the civil and the criminal were taken away, my lord. And there, this judgment was followed by Navam Nikum case. The Navam Nikum case, my lord, in 2016, it was clearly distinguished judgment rendered by the Lordship B.K. Sarma Division Bench. Till the AFR is suitably amended, the appellate authority will be the deputy commissioner and they will continue to decide those. This was there. Now, after that, my lord, then 2011, two district and two station divisions were created in Arunachal. One in UPI and another in which part I forgot. Teju, my lord. Two station. Two.
Are you sure?
I'm sure, my lord. East and West station divisions were created.
Okay. Which
So,
year?
2011.
Okay.
That Sir Buddhi Habung and the Sir Grayu was appointed as the first district and sessions.
Okay.
That with fact, at least I cannot be wrong on that.
Okay.
So then, my lord, what had happened? The regular civil and the criminal court came to be in effect established in Arunachal Pradesh.
Let me dictate the order. If you are not satisfied, we will give you further time to argue.
No, I was I was placing the facts only, my lord. So there's then in that case, my lord will kindly issue notice. Let's see.
No, see, let us see. See the order. This is a provisional, huh? Subject to further correction. The petitioner is agreed by order dated 5
My lord,
2017.
I request one thing.
Yes.
My lord I request for only issuance of the notice today.
But I don't find any prima facie case of issuing a notice under 226 in this case. You are challenging a order passed by the deputy commissioner in a land dispute case.
Well,
Either patently illegal or no jurisdiction, you have a remedy before the civil court. This is a writ court.
No, my lord, that's why the same thing was put into challenge in this court under 226. And this authority is with me. So, my lord, I understand.
But as far as the understanding of this court, insofar as 226 is concerned.
227 is the right thing, my lord. So, my lord, here also I have faulted with. So, therefore, my lord, kindly afford me a liberty. Afford me a liberty, my lord.
What kind of liberty?
To withdraw and file fresh, my lord, by invoking appropriate provision, my lord.
Dismiss on withdraw.
With a liberty, my lord. With a liberty to file fresh, because there is liberty is already granted.
So, but you are strenuously arguing that this petition is maintainable.
No,
and what happened at the last moment that? Huh?
No.
To withdraw this?
My lord, we are
travel to Bengal, Agra.
No, my lord, we are a council, my lord. We are a council before my lord. And then when certain things falls down from my lord, it is our duty to answer it. So therefore, my lord, kindly with the liberty, because liberty
with a liberty.
With a liberty, my lord. I'll come back with this Surya Devi judgment of 2003 and Radhesam Chabi 2015 judgment, my lord, at later point of time. There's law is settled, my lord, because in this case, my lord, Surya Devi was finally settled in Radhesam Chabi case. In case of civil dispute, it should be 227, read with 151. That is the law, my lord. I'm grateful. Well, this poor fellow was denied with the NOC for getting the pensionary benefits, my lord, and finally has been discharged from that criminal case. I place this particular order. Discharge order is there, my lord. Kindly in the review petition, my lord, review petition of this particular case was before my lord. I lost the case. But
Which one?
The Danigambo case is connecting to this. And this Yumogai is one of the petitioner in that. PC Act case. Now, finally, it has been remanded back to the special court and has discharged all the alleged accused person. So this was the case which was preventing the SIC from issuing the NOC. So now they have been discharged. Kindly direct them to give the NOC and process the pension paper of the petitioner.
Which is the impugn order?
Impugn order, there is no impugn order as such.
There is no impugn order as such. What is the grievance of the petition?
Grievances of the petitioner, NOC, non-issuance of the NOC.
Certificate. So it's pensionary benefits. You retired as what?
I retired as a superintending engineer, on 28/2/2022. My lord will find at page 15.
28 to
2022,
2022 as superintendent
engineer.
Which department?
PWD.
PWD.
Office order. Then page 16, to whom it may concern, certificate was given that I have not encroached any government land. And also from the Itanagar.
Now this vigilance clearance certificate is to be issued by whom?
By the secretary, by the Department of Vigilance, Page 19 will come,
Respondent number 2.
Yes, Lord. Page 19, is important for the reference.
Yes.
They have written it, The chief engineer, concerned chief engineer has written to it. Then this was not acted upon, Then finally, I have submitted a representation at page 22, Then thereafter, I was informed. Then I wrote to the Secretary of Vigilance 4/8/2022. I read this paragraph. This is to inform you that consequent upon my superannuation from the services as SCPWD on 28/2/2022, the chief engineer have written a letter dated 17/02/2022 being memo number so and so to issue vigilance clearance in respect of undersigned so as to enable the PWD department to process my pensionary benefits. That it is pertinent to know that even after lapse of 5 months, the Department of Vigilance is yet to issue the same nor have made any communication to the Department of PWD, either of rejection or to grant vigilance clearances, so as to enable the Department of PWD to process the pensionary benefit of undersigned. Well, that was only in connection with this particular case, the vigilance was not given. Professor, that Jharkhand case, Jitendra case, is aware, and my lord have also done. Even the Kapakoli also, my lord have interfered where I appeared. And Dr. Hilar case also was 2020.
Yes, Pangu. What do you say?
Discharged.
Yes, your lordship, criminal case is closed, your lordship. Let the authority to take decision.
Okay. We'll direct you to submit this discharge order.
Correct.
Before the
Authority.
Secretary Vigilance, and Secretary Vigilance will pass appropriate orders.
Correct.
Mr. Titital and the counsel for the petitioner, and Ms. P. Pangul and the government advocate representing the respondents. The petitioner is aggrieved by non-payment of his pension. The petitioner who retired on 28/2/2022 on attaining the age of superannuation as Superintendent of Engineer PWD has filed a state petition raising a grievance that he has not been paid his pension due to non-issuance of vigilance clearance certificate by the respondent number 2, the Secretary Vigilance, Government of Arunachal Pradesh, which is which is required for processing the pension papers of the of an employee who retires on attaining the age of superannuation for the purpose of payment of the pension. Also, the Learned Counsel for the petitioner now submits that the petitioner who was one of the accused in PCA number in PCA number 01/16 dash in SIC vigilance YZL/PS number 5/11 through so and so. You write this title. Did I say one of the accused? One of the accused pieces so and so, who has now been discharged by an order of the court, by an order of the special judge PCA UPA dated 4/4/2023, passed in the opposite case. Accordingly, Learned Counsel for the petitioner submits that there should now be no impediment on the part of the respondents to issue vigilance clearance certificate to the petitioner. Having heard the Learned Counsel for the petitioner and Mr. Pango, Learned Government Advocate, this petition is disposed of with a direction to the petitioner to submit a copy of the order dated 4/4/2023, passed in PCA number so and so, to the respondent number 2, the Secretary Vigilance, Government of Arunachal Pradesh. Whereafter the Secretary Vigilance, Government of Arunachal Pradesh, respondent number 2, pass an appropriate order in accordance with law, insofar as the issuance of vigilance clearance certificate to the petitioner is concerned. Shall we fix any time limit?
Time limit, outer limit of 2 weeks.
Okay, within a period of 2 weeks from the date of submission of the order dated 4/4/2023, passed with PCA along with a certified copy of the order.
In the meantime, kindly small direction to the respondent number 3 also. That my prayer number 2 at page 13 to process the pension papers of the petitioner with or without vigilance clearance in view of the discharge.
No, see, this respondent 2 will now issue you a vigilance clearance certificate.
Correct.
If they had to hold up this that certificate because of this case. Now, after that is issued, then the PWD department will act upon that. Is not it?
That might not have used the sentence, most probably pass an appropriate order on submission of discharge.
No.
No,
Pass an appropriate order regarding issuance of vigilance clearance certificate to the petition. That is what I've said. See, appropriate order, why it is required? You are discharged in this.
yes.
If you have some other case, we can't take give a direction to the secretary to straightway issue you a always is not it. So he will pass his appropriate order. If you have no other case pending, then he is bound to take he is bound to issue a vigilance clearance certificate.
Yes, I understand the susceptible of a tight pressure cooker, taking care of all the aspects. Grateful.
May I please, Lord. My lord, in this matter, Deputy Commissioner has already filed the affidavit, my lord. The matter may be admitted and listed for hearing, my lord. My lord, my lord, the matter pertains to the construction of NH 415, my lord. Here, my lord, this notification, my lord, was issued in 2016, my lord. I'll just cursorily, my lord, take your lordship to the main points only, my lord. So,
payment of pension.
my lord,
Non.
yes, compensation amount. Yes.
Okay.
My lord, this is the place, my lord, our place is the viaduct which is being constructed, my lord. But is obviously it would be not within the ROW because it's totally in a new road, my lord, in a new area it's going on. So this was, my lord, conducted in 2016, my lord. And
Similar petition was listed.
yes, sir. There's many cases, similar cases. And my lord, the compensation was assessed in 2016 itself, my lord.
No, how many such petitions are pending?
Around, I'll have to check it, but around 15 or 10, more than 10, my lord.
Then all those may be hard together.
Yes, but it would be better, my lord. No, but the reply that has come is all different in different cases. Man. Here, the only answer given by the deputy commissioner is that you have not given the, that was not the question before, not disbursing amount. Now they have come up with an affidavit saying that you did not produce forest NOC from forest. Man. Whereas, when the assessment was made, 2016, the DFO himself was one of the members who assessed the board members, 2016. Under the DFO. He was one of the members who assessed the land and he had no objection. 2016 to 2021, nobody raised forest department any objection regarding the plot. Now, even the board didn't raise objection. And it is only the deputy commissioner in his own capacity is raising an objection regarding not issuing if the area is forest.
No. Today, what is to be done? Are we,
yes,
are we hearing the repetition or?
No, that's why I'm submitting the matter may be admitted, may be listed for hearing.
No, we'll hear all the petitions together. I think you are appearing for all the petitioners.
Yes, madam. But reply in different petitions are a bit different, madam. That's why.
Doesn't matter.
Yes.
Matter relates to this casting sub point.
Yes, ma'am.
And non-payment of a compensation.
Yes.
As per the earlier assessment made.
Yes.
That is the issue.
Yes, ma'am.
Reasons may be different.
Yes.
Do you give the numbers?
Otherwise, yesterday, two matters they were supposed to be listed after 2 weeks, man.
2 weeks. Okay.
Yes.
We will also say that list after 2
yes.
weeks in the
like the Commissioner Print furnished the list of those cases.
Yes, but after 2 weeks,
So then it can be taken up.
if those matters come up, I will tag all the matters together. After 2 weeks, yesterday, yes.
Take it.
Yes, ma'am.
All
Because in that affidavit was not filed yesterday's matter.
That's Mr. Kapul and count this after 2 weeks.
Yes, obligement.
May I plead, my lord? This
I
matter,
will-
my lord.
Before my learned friend starts, I will pay for some more time to file affidavit, my lord.
Yes.
My lord, in this matter, my lord, this is, we are agreed by the memorandum issued by the state government suspending the constitutional member, National Pradesh Public Service Commission member, my lord, without following the constitutional mandate under Article 317, Clause 1 and Clause 2. If suspension has to be done, it has to be done as per the procedure of Article 317 sub Clause 2. This is a clear violation of that provisions. That's I want to, in fact, like listen last time, but now it's almost 24 days they have been given time. And last time also we tried to pray for an interim, but then your honorable court was pleased that if they don't file this time, next day, the interim may be considered. That was the order.
So I will pray that if they are taking time, then my lord, this is a clear case. The honorable court can interfere because this is a clear violation. I can just I can also place some of the authority, which also clearly shows that this is a clear violation of constitutional mandate, Article 317 subclause 2. So just how this is the impugn order is a clear violation of Article 317 subclause 2. I will just take to the impugn order, my lord. But impugn order is in page 29 to 30, my lord. It's a annexure B. May I read just from the beginning, my lord? This is a case of the FPCS fiasco after the examination of A Sibyl. I just count out of that. Well, I will just read this memorandum. It was issued on 15 June 2021. May I read from the beginning?
Let them file affidavit.
Yes, my lord.
Let them file affidavit.
But they are taking time, my lord, because its constitution is basically Article 317 subclause 1 is to protect the constitutional members, my lord. Only removal can be done only by the president. But that also as per the procedure mandated by under 317 subclause 1 and subclause 2, the government cannot issue the suspension order unless they follow the procedures, my lord. But then they have not done. I can just only read, otherwise I can just only read serial number 8 and 9 is very important. Serial number 8 and 9. And then I will just place the judgment. It's a clear case of the violation of constitutional mandate, and it's unconstitutional. This impugn order is unconstitutional, my lord. I will just place the your lordship, my lord. May I read para 8. May I read? From para 7, the Honorable Governor White letter dated such and such 02/12/2022 had requested Honorable President of India to place the reference before the Supreme Court of India under Article 317 clause 1 of the Constitution of India for the removal of the remaining members FPPSC Miss such and such 8. Whereas the Undersecretary to the Government of India, Ministry of, this is a issue with the Ministry of Personnel, my lord. Ministry of Personnel, Public Grievances and Pension, Department of Personnel and Training, Government of India, White letter dated 3rd May 2023, had forwarded on the behalf of Her Excellency, my lord, this is very important, my lord, forwarded on behalf of Her Excellency, whereas Excellency, the President of India, a copy of reference made to the Supreme Court of India in respect of such and such member of Arunachal Pradesh Public Service Commission under clause 1 of the Article 317 of the Constitution of India, whereas it says that forwarded on behalf of the President of India, whereas the Constitution doesn't mandate that one. It has to be forwarded by the President of India, applying his judicial mind. I will just play that judgment, my lord. And then 9. Whereas clause 2 of Article 317 clause 2 is talking about the suspension, my lord. The Constitution of India provides that the President of India, in the case of the Union Commission or a Joint Commission, and the Governor in case of a State Commission, may suspend from the office and chairman or any other members of the Commission in respect of whom a reference has been made to the Supreme Court under clause 1 until the President has passed the order on receipt of the report of the Supreme Court on such reference. We have placed the order 43 of Supreme Court rules, which also talks about if the reference is sent by the President of India, it has to be received by the Supreme Court under order 43, and then it has to be report has to be sent back to the President, and the President can only order, not on the behalf of some other functionaries can forward on the behalf of the President, my lord. It cannot be done, my lord. The Constitution provisions is very clear, my lord. And then 10, my lord. Whereas on receipt of aforementioned, the communication from the Ministry of Personnel, Public Grievances, Personnel and Department of Personnel and Training, Government of India, the Cabinet in its meeting held on 31/5/2023, after detailed deliberation, resolved to recommend to the Governor of Arunachal Pradesh for suspension of such and such member Arunachal Pradesh Public Service Commission under clause 2 of Article 317 of Constitution of India. and 11, my lord, page 30, my lord. And therefore, after considering the reference made by the Her Excellency, President of India, to the Supreme Court of India under Clause 1, Article 217, Constitution of India, a view of learned Advocate General and Arunachal Pradesh, relevant facts of the whole issue, the Governor of Arunachal Pradesh is pleased to order the suspension of Ms. Such and Such, the member of Arunachal Pradesh Public Service Commission under Clause 2 of the Article 317 Constitution of India, immediate effect with until. Now here, my lord, I want to point out is that the president has not sent the reference to the Supreme Court. That is one. They are saying that it is forwarded through the Ministry of Personnel and Grievances. That is one. Second is that they have not mentioned whether the Supreme Court has received under Order 43 Supreme Court Rule 1966. They have not mentioned, because as per they have to mention name of the case when it is registered, under which charges, under which section they are being charged. It has to be mentioned in that order, my lord, in the reference, my lord. But it has not been, that is not clear. And whereas Constitution mandate, it says that President himself has to send the reference. I will just place that order, my lord. My lord, I have given the list of that, my lord. And the power of the governor, my lord. How the government can pass the order, my lord. My lord, I will just take to the first is that how the procedure to be followed. That first I want to place that one. 2009, volume 9, SSC 378, para 8. I want to say that this is because it has to be, procedure has to be, it has to be, they have to follow as per the procedure established the law and not in derogation of same. Para 8, my lord. I'll just go read the para 8. Para 8, may I read? It is not necessary that the principle of audit alteram partem rigorously followed in the domain of service law need to be applied with the same degree of rigorous in proceeding involving the removal and suspension of the member of State Public Service Commission. This is exceptional treatment is mandated by Article 317. Furthermore, this is important, my lord. Furthermore, the issuance of suspension order is as per the procedure established by law, not in derogation from the same. Now, I will in the support of that, how this suspension has to be issued, my lord. And now I will just take to another judgment, my lord. 2010, volume 13, page 358. Relevant paragraph is 31, my lord. Relevant paragraph is 31, my lord, marriage. Making reference to this court, my lord, reference to the Supreme Court, my lord.
Yes.
Yes, para 31, my lord.
Yes.
Yes, married. Making reference to this court under Article 317, subclause 1 of the Constitution, invokes the reference advisory jurisdiction of this court. In the scheme of the Constitution relating to this aspect, it is clear that before the reference can be made to this court, certain procedure is required to be satisfied. The governor, acting on the advice of the state government, would request the president for taking steps for removal of a member in accordance with the provisions of Article 317, clause 1 of the Constitution. Governor only can request only under to remove under Article 317, clause 1 of the Constitution. There is requirement proper application of my lord, this is important, my lord. There is a requirement of proper application of mind by the president while making a reference to this court, and it is but a natural that reference to this court would be made only when the president is satisfied that a prima facie case of misbehavior is made out, my lord. No other functional can send reference
to the president to the Supreme Court, my lord. The affects court judgment is very clear that the president has to satisfy himself that a prima facie case of misbehavior is met out. Then only it can be sent, my lord. But whereas in our impugn order, it was forwarded by the Ministry of Personal and Grievances, and accordingly they have suspended the member
Yes.
of the commission. My lord.
When will you file affidavit?
Another 4 weeks time may be granted.
Why 4 weeks?
There is an instruction. Otherwise, reference has already been given to the Supreme Court, my lord, forwarded by the president, my lord. And to that effect, we have the instruction.
Hmm.
And it is also mentioned in the impugn order itself. It was on 3rd of May 2023. His only case is that 2 limbs that till date there is no reference made by the president, and in the meantime the governor has suspended her. Second is that the reference made by the president to the Honorable Supreme Court is not by the president but rather by the ministry, only in the name of the president. To that the second limb of.
But it is constitutional. Even for one day also, it's unconstitutional. They cannot
That's
do
fine,
that way.
my lord.
Because
I-
this constitution, this provision is being done to protect the member of the
Yes,
member
my
of the Public Service
There
Commission.
is no quarrel
They
in
cannot,
some,
they cannot do
authority
the
you are
derogation
relying-
of the constitution provision, my lord.
The
So even
very
for-
authority you are relying, there is a
So you
judgment
should-
of Samsar
but you
Singh
should-
case, my lord, 1974.
But you should have come out with a reply.
Yes,
They,
my lord,
they have got
these-
enough time for
these-
24 days. They're not able to reply, my lord. That's what I'm praying for the entry. my
These
lord.
are legal matters which need not, which can be replied in submission.
I'm submitting with the effect judgment.
Yes,
It is
my
that
lord.
you
That-
have
that-
committed the
that-
constitutional
I'm also
violation of
citing-
constitution.
I am also citing Samsar Singh judgment, 1974, 2 SCC, page 831, wherein it clearly says that the president has to act on the act and aid and advice of the Council of Ministers. The very judgment he is relying, that also has been relied in that very judgment, the Samsar Singh judgment has been relied.
All right.
Para 30 and 31.
All right.
That's why till that they file affidavit, my lord, I will pay
There
for
cannot be
the
any.
for the
Had
big-
Mr.
entry, my lord.
S. Mohan counsel for the petitioner. And Mr. N. Ratan Lalit, AAG for the respondent. On the prayer of Mr. Ratan Lalit, AAG. 3 weeks. Further time is granted for filing of a counter affidavit. List it after 3 weeks.
My lord, what my learned friend is trying to impress upon this court is that the satisfaction has to be then the personal satisfaction of the president, which cannot be, my lord, which
You
has been
file-
clearly
You.
in
file
Samsar
affidavit.
Singh judgment, my lord.
Because
Article 317.
my lord is aware
Itself,
that there is a
Article
FESCO,
317 has been mentioned
official
where-
FESCO is there, but then there is a high power in committee report. There is a CBI charge, not even a single, no any charge has been implicated on the petitioner, my lord.
It is not the personal satisfaction of
That
the
is my,
president.
that
It
is my, in
the
my petition also that way, my lord.
satisfaction
There is no any
regard
allegations
to
against
the
the member, my lord.
constitutional
If he
satisfaction.
has
which
to be
means the
suspended,
Satisfaction of the
then it has to be done
aid and-
as per
with
the
the aid and advice of the Council of Ministers.
317 or sub plus 2, my lord. That is my prayer.
After 3 weeks.
Well, that's what my intent.
Dispose of the matter, intermatter. Once the
Then,
affidavit.
my lord, it may be written, it may be that they make sure that they file a reply, my lord. That,
That is why 3 weeks.
and my lord, and other party, my lord, central government, I think is represented by Kato, and his name is not reflected.
Who?
M.
Mr.
Kato.
Kato.
No, it is for him to appear or not appear. How?
But in the
What
cost
is
list,
it?
it's not reflected, my lord.
Huh?
In the cost list, it's not reflected. So
Central
let us say they may take that,
Just a moment.
Yes.
Union of India is a party.
yes, my lord.
Which respondent?
Ministry of Personal and Public Grievances, my lord.
Which respondent?
My lord, I will just check to the response.
Uh,
5,
5, 6.
5,
5 and 6.
5 and 6, my lord.
Union of India is a party.
Yes, ma'am. My lord, yes, my lord. We have met only the Ministry of Grievances only.
In that case,
You appear for 5 and
yeah,
6.
let's-
Oh,
In the meantime, it is not.
Because their submission is on the basis of the forwarding of that Ministry of Personal and Pension, my lord.
This is after 3 weeks by showing the name of Mr. M. Carter on the DSGY in the cause list as counsel representing respondents 5 and 6.
For my lord, I will also pray that can be fixed for a disposal, my lord.
We'll
It
dispose.
can be reflected in my lordship order, my lord.
How can I bind the future court?
Because they are only dragging the matters, my lord. That's what
Yes, after 3 weeks.
obliged. Myself. May I lordship respondents yet to file their affidavit, lordship.
My lordship, we have received our instructions, my lordship. We'll be filing. We need some more time.
What is the matter about?
A matter about lordships, this is an land lordship, land dispute case, lordship. Land under Public Premises Act, lordships. Appeal was filed, lordships. Before the Deputy Commissioner Ying Kyung, lordship. Ying Kyung, Deputy Commissioner, disposed of the matter, lordships, against the petitioner, lordships. Now that side order was challenged before by this petition, lordship.
Mr. G. Vam, counsel for the petitioner, and Ms. K. Wangwal, government advocate, for which respondent?
1, 3, and 4.
1, 3, and 4, who submits with the. Who submits the CA receive instruction to file contract for which she pressed for and is granted 3 weeks time.
In
Yes.
may we continue, lordship.
Listed after 4 weeks. Interim order pass service will continue till the next date of listing.
Much.
What is the matter about?
If the petitioner is asking for departmental proceeding,
Huh?
the petitioner is asking for departmental proceeding against the lordship by respondent number 4.
Department of procedure.
Yes, he is the lordship inspector lordship, this department. He is married to one Mohit child as his second wife. So the petitioner is the first wife of my child.
Okay. Mahesh Chai is the government servant.
No, the respondent number 4, the Pang Wong is the government servant,
Okay.
who is known as his second wife.
Her husband. Respondent 4 is her husband.
No, 5 is husband.
Oh, 5 is husband. Oh,
5 is husband, 4 is the second wife.
second one.
Petitioner is asking for the against the respondent number 4 because he has come as a second wife.
Second one. Is there any provision?
So if can you see it can be disposed of nothing. Yes, one advice opinion of the department. Can you see the page 14? Page 140.
Of the repetition.
No, this affidavit filed by the state government.
Respondent number 3.
Respondent number 3, correct. This replaces the lawsuit, the legal position lawsuit.
Okay.
At page 14.
Page 14.
140.
Yes. Yes.
In inviting a reference to your list and so, dated so and so, on the above cited subject, I am directed to inform that a government servant is restricted by Rule 21 from contracting a second marriage with a person having a living spouse, unless permission is granted by the appropriate government under Rule 21A of B of CC's Conduct Rule 1964. In the present case, the government servant appears to have attracted the provisions of Rule 21(1) of the CC's Conduct Rule 1964. However, as per the provision to the rule, such marriage as in the present case could be permitted if the personal laws applicable to both the government servant and the party to the marriage allow. It is therefore advisable for the department to consider issue in the light of above rule and personal law applicable to the parties. In view of this lawsuit, the authority can take decision lawsuit either to go ahead with the lawsuit departmental proceeding or not. Since department has not gone ahead or come to a logical conclusion, so under this circumstance, this writ petition has to be filed. This Honorable Court cannot direct to go with the departmental proceeding, but to take a decision to reach to a logical conclusion, either to go ahead with or to close it up. So to that extent, if direction is given and matter can be closed.
You are for whom?
My lord, I'm for respondent 4 and 5.
4 and 5.
My lord, in this matter, leading counsel is unable to take up the matter. So we juniors are taking the matter, so may sometime may be granted.
4 has married to respondent number 5.
Yes.
As a
yes,
second wife.
As a second wife.
None
And
is-
my lord, I'm on instruction, so I have no any much idea about this matter. So may
See-
some time to grant it.
See, what is happening in this case is this petitioner is seeking some action to be taken against this respondent number 4 by the government on account of respondent number 4 having contracted marriage with 5. She may be alleging some violation of conduct rules, something like that. So what if there are any violation of the conduct rules? It is the government who will have to take a decision, is not it? So we will not direct the government to take action. We will direct the government to take a decision. So that way it will not prejudice anybody. Government will have to take a decision. Complaint, what is the complaint, Mr. Tapin?
It's page 17 also.
17.
Annexure 2.
Okay. I think we can dispose of in that line. Government will take a decision. Maybe in your favor, maybe against you, against you. And you will have further remedy.
Okay, madam.
None appears for the petitioner. Out Mr. S. Tapin, senior government advocate for respondent 1, 2, and 3, as well as Mr. Your name?
Timite, my lord. Timite.
T. Mite,
Yes, my lord.
Learned Counsel for respondent number 4 and 5.
This writ petition has been filed by the petitioner seeking a direction to the respondent authorities to take action against the respondent number 4 by initiating a departmental inquiry on the basis of the complaint dated 3/7/2020 lodged by the petitioner against the respondent number 4, alleging violation of Rule 21(1) of the Central Civil Services within bracket Conduct Rules 1964. Also, on perusal of complaint dated 3/7/2020 lodged against the respondent number 4 by the petitioner before the Director General of Police, Arunachal Pradesh Police, former Chief Secretary, Governor Arunachal Pradesh, and Secretary Home, Governor Arunachal Pradesh, it appears that petitioner is the wife of respondent number 5. Have they married? Respondent 4 and 5?
Lordship.
Married. Is there anything to indicate they married?
Lordship.
Okay. Is the first wife of respondent number 5. And the petitioner, sorry, the respondent number 1, who is an inspector in the Arunachal Pradesh Police, has been alleged to have contracted marriage with the respondent number 5 as second wife of the respondent number 5. Also, though this requisition has been contested by the respondents by filing a counter affidavit, but having regard to the nature of prayer made by the petitioner in the instant case, and also in view of the fact if at all the respondent number 4 have violated the Central Civil Service Conduct Rules 1964 by allegedly marrying the respondent number 5, who is the husband of the respondent number, the petitioner. It is for the competent authority of the state government to take a decision in the matter whether action against respondent number 4 is required to be initiated under the law or not. Under the circumstances, without expressing any opinion on the merit of the allegations made in the allegations made by the petitioner against the respondent number 4. This writ petition is hereby disposed of with a direction to the respondents, namely, who will take a decision?
Lordship,
Who will direct all
the complainant has been lodged before
before the three authorities,
the, I think,
Director General,
Director General will take this.
the Director General of Police, or Mr. The APP, the respondent number 3, to take a decision on the complaint dated 3/7/2020, lodged by the petitioner in accordance with law. That much, I think.
Yes.
Also, writ petition is disposed of with the above direction.
Lordship. Here, this case may be fixed for hearing.
What is to be heard? Yeah.
Here,
Your
our
lordship, and they have still not furnished us extra copy, your lordship.
Oh,
Petitioner, your lordship.
extra copy was submitted earlier.
what is the matter about?
Not to us, your lordship.
The matter is pertaining to, my lord, challenging the validity of the impugn order, Annexer D, passed by the learned State Commission of State Movement Commission. So against me, because allegation was that sexual harassment at the workplace.
See whether the matter still survives for any decision of this court. When the matter has been resolved.
But the respondents are not replying. Respondent number 2 and 3, day before yesterday, submitted their affidavit.
Who? Respondent number?
2 and 3.
Okay, who are 2 and 3? Rural Development
Yes, yes,
and Director.
yes. So other respondents, they have approached before me to settle the matter outside. And respondent number 8 is yet to file any affidavit.
Who approached you to settle the matter outside?
This respondent number 4,
4.
respondent 4, 5,
Okay.
6 and 7. They approach, but I will have to take instruction from my client. So 4-week time may be given, my lord. So in the meantime, we will try to settle outside, and thereafter we will file affidavit before this honorable court.
Who is appearing for respondent of 4 and 5? Anybody?
It was my learned brother Bintar P. Sabat. He is absent today.
But the office note indicates that 4, 5, 6 have not been served. And you are required to take police steps. Picha is for RD department.
RD department.
You are for whom? Pangu?
I'm for respondent number 8, your lordship, Women Commissioner. Till today, they have not furnished extra copy, your lordship.
Yes, why have you not furnished a copy?
Extra copy. Pardon, my lord, I will file just today only because my associates filed before. I think it might have been misplaced. So today only I'll file, my lord. I'll submit today only extra copy to the respondent number 8.
Which is the order you are challenging? Which is the order you are challenging?
Already the other, your honors directed to pay the arrear and salary and to release, everything has been completed, my lord, as we complied. Only remaining is that the impugn order we are challenging here of the State Women Commission.
At page number? At page number?
At page number DD, so annexer D, page number 123.
123. On what ground you are challenging this?
My lord, the respondent number 4, he was my subordinate officer. So without any authority, she remained absent for 3 years. So I requested the authority to held up her payment and allowances and to show cause action. But the authority didn't issue any show cause notice again, the respondent number 4. But later on, she approached before the London State Women Commission and filed a complaint against me. And on receipt of the complaint, the London State Women Commission issued this communication letter to the director.
Then
So accordingly,
See,
your
Mr.
lordship directed
Mr.
and we
Dekker,
complied.
you do one thing. You serve this respondent number 4, 5, 6 by Dusty.
Okay, my
Okay.
lord.
Otherwise, this case is not going to go anywhere.
My lord, I'll serve
And what about extra copy to her?
extra copy today only.
Okay.
I'll hand over
Had
today only.
Mr. U. Dekker, learned counsel for the petitioner. And Ms. P. Pangu, learned counsel representing respondent number 8, who submits that extra copy of the writ petition has not been furnished to her till then. In view of the above, Mr. Dekker undertakes to furnish a copy of the extra copy of the writ petition to Ms. Pangu during the course of the day. those stuff. It appears from the office note dated. Yes, so. None has appeared for the respondents 1, 2, and 3. Do the name of Mr. Pitcher. B. Pitcher, understanding counsel for the art department, is shown in the cause list. Office note dated 9/9/2022 indicates that respondent number 7 has been served, but respondents 4, 5, and 6 are yet to be served. Which position in respect of the respondent number 4 and 5, 4, 5, and 6, insofar as the notice upon them is concerned, has what did I say? Insofar has again been reflected in the recent office note dated 18/7/2023. Full stop. In view of the above, Mr. Decker and the counsel for the petitioner submits that he may be allowed, the petitioner may be allowed to take justice service upon respondent number 4, 5, and 6. Prayer is allowed. The notice upon respondent number 4, 5, and 6 shall be served by Dusty, served to Dusty by the petitioner within a period of 3 weeks.
Yes, my lord.
3 weeks from today, whereafter an affidavit to that effect shall be filed. Also listed after 4 weeks.
Okay. Highly obliged.
May Lordship. Lordship, I'm representing respondent number, private respondent number 5.
Yes.
We may allow some time to file our affidavit in opposition.
Yes, what is the matter about?
That is about the cancellation of the
Contractual
Contractor-
registration certificate.
certificate, my lord.
What certificate?
Contractual.
Enlistment of contractors
Yes, ma'am.
issued on
Issue 12/10/2021, my lord.
12/10/2021. This enlistment. What is called enlistment certificate or order?
Order, my lord.
Does it have any validity period?
I don't.
What is the certificate? Yes, Pangu, any idea? What is the certificate?
Copies of certificate is in my lord, page number 27, ma'am.
27.
Yes, ma'am.
Twenty-seven. 11th February 18.
Yes, ma'am.
Anybody has any idea about the validity of this certificate, this order? Nobody has any idea. What for you would like to file affidavit, mister? What is the cancellation order?
Cancellation order is in my page number 55, my lord.
Huh?
55 and 56.
55.
55 and 56.
55 and 56.
Yes, ma'am.
October.
Yes, my lord.
You are yes, it is for 5 years. 5 years is expired. What for you would like to file an affidavit? Miss Pangu, you should be aware of this. Huh? Or Mr.
The other, my lord.
The other counsel for the petitioner. P. Pangu for Which respondent?
1 to 4, Your Lordship.
R? 1, 2,
4, Your Lordship.
1,
1,
2,
3 and 4.
3 and 4. And Mr.
Yes, sir, lordship. Yes, sir.
Yes, sir, hold on, council for respondent number 5. This writ petition is directed against the order dated 12 October 2021. Passed by the Chief Engineer CSQ Public Works Department. By number so and so at page 55 and 56. Whereby petitioners enlistment as contractor by office order dated enlistment as enlistment as class 1 within bracket B and R under civil category as per the provision of Arunachal Pradesh enlistment of contractors in Works Department Rules 2008 issued by the Chief Engineer CSQ PWD AP by number so and so at page 27A has been cancelled. Full stop. The petitioner was enlisted as class 1 beer under civil category as per the provision of so and so Arunachal enlistment so and so by the order dated 11 February 2018 issued by the Chief Engineer CSQ PWD by number so and so same, which has been annexed as annex A Collie at page 27A. Full stop. To the writ petition. Full stop. On perusal thereof, the certificate. No, the enlistment of contractors. On perusal of the office order dated 11 February 2018. Enlisting the petitioner as class 1 BNR under civil category. Just a moment. On perusal of the office order dated 11 February 2018, it appears that the validity period. Just a moment. It appears that enlistment notified by the office order dated 11 February 2018 is valid for an initial period of 5 years from the date of issue of the order, whereafter an application is required to be submitted 6 months before the expiry of their enlistment for its revalidation. Full stop. Have you submitted an application for revalidation?
Might be, my lord.
What did I say? Valid for 5 years initially, whereafter? Then you write, it is valid initially for a period of 5 years, whereafter it has whereafter the same is required to be revalidated, for which an application for revalidation is required to be submitted 6 months before the expiry of their enlistment. As per clause 9 of the office order dated 11 February 2018. Also, no material has been placed by the petitioner that and just a minute, before that, this enlistment of contractor of the petitioner by the order dated 11 February 2016. Sorry, 2018. Being more than 5 years old, there is no material. It's a comma. No material has been placed before this court by the petitioner that an application for revalidation of the opposite enlistment order dated 11 February 2018 was submitted by the petitioner. Before the appropriate authority for revalidation of the enlistment of class 1, B and R for revalidation of the petitioner as class 1, B and R under civil category in terms of as per the provision of understood projects, enlistment of contractors in Works Department Rules 2008. In that view of the matter, nothing survives to be adjudicated in the read petition. As the enlistment order dated 11 February 2018, whereby the petitioner was enlisted as class 1 B and R under civil category. Has spent its force as per clause 9 of the order dated 11 February 2018 itself. The writ petition accordingly stands closed. Okay,
My lord, earlier, I Chaudhary was leading this case, my lord.
Who?
I Chaudhary, my lord.
Then
Due to his appointment as a AG of the AP, he could not.
you apply for a fresh enlistment. Without it.
Yes, ma'am.
Did the petitioner submit application for revalidation? No.
Up to date, I don't know.
Okay. All right.
May Lordship.
Hmm.
Lordship, respondent number 2 not yet filed affidavit, Lordship.
What is the matter about?
Lordship, I am prepared for a question set aside the someone issued by the Women Commissioner, Lordship.
Someone issued by the Women Commission. Let
Lordship.
us see.
May I, Your Lordship? Your Lordship, I am for the respondent number 2 and 3. And for 3, I have filed the counter affidavit. And for 2, Your Lordship, I am yet to receive Parava's reply. So time may be granted, Your Lordship.
What is the order you are challenging?
Lordship, at page number 26, Lordship.
26.
Okay. That copy is at 27 also.
You have been summoned as a witness.
No, Lordship, for taking copy.
What is your name? What is your name?
Lordship,
No, your name.
yeah, Lordship,
Roland.
Lordship,
Have you read the brief?
Lordship.
Yes. What is the impugn order?
It's a case 26 to 30, Lordship. 26 to 30, Lordship.
26 to 30.
30, Lordship.
What is 26?
Someone for witness, Lordship.
So what is wrong with this?
Lordship, private respondent number 3 and petitioner number 3 is a husband and wife. Permanent resident of
Petitioner and respondent number?
petitioner number 3 and respondent number 3, Lordship. The husband and wife, permanent resident of Blaise Bandadua Boligao, P.O. Patali, P.S. Bipuria, district North Lakipur, Assam, Lordship. I'm challenging that both are from outside the state and complaint made in Arunachal Pradesh Women Commission, Lordship. Women Commissioner has cognizance, taking cognizance and issuing someone without jurisdiction, Lordship.
Petitioner number 3
And private respondent number 3.
3, they are husband and wife.
Lordship.
Now,
Petitioner number 3 is made complaint against respondent number 3 made complaint against petitioner number 3, Lordship.
okay, against your husband, against
Her husband, Lordship.
against her husband
Lordship.
for domestic violence.
Lordship, Lordship.
Women Commission can take up a case of domestic violence.
Sorry, Lordship.
Huh?
I'm
Where
sorry.
is the Women Commission Act? Yes, Riram. You represent whom?
Respondent number 1.
One. Does the Women Commission have the jurisdiction to try a domestic violence case? You are Mr.
E. Menjo. I'm for the respondent number 2, Women Commission, and 3, private respondent.
Do you have the power to try such cases?
Your Lordship, I'm not sure about that. Therefore, we have asked for detailed paraphrase reply from the commission.
Then how will you defend? It is an AP code. Yes, anybody can tell whether Women Commission can try a domestic violence case.
My lord, the power of the Women Commission, there is something called unfair practice. Unfair practice against women just because she's a woman. If any sort of any sort of unfair practices done against her, if it comes within the definition of that, then Women Commission can take up the case. Now, this will include all sorts of violence, whether domestic or not. Of course, the Women Commission cannot try like a court, but they can make a recommendation if they find that there is some sort of discrimination against her. So it will depend on whether it comes within the definition of unfair practice.
One zero nine. 109. So Menjo, how will you represent Women Commission? Who has filed affidavit?
Respondent number 3, Lordship.
3.
Lordship.
3 is the complainant.
Lordship.
But respondent, sorry, this petitioner number 3 is serving in the APP.
Yes, Your Worship.
You're a resident of PTC Bandadra.
No, Lordship. Lordship, I am.
Are you serving in the APP or not?
Yes, Lordship.
Then why is this Special Commission shall not have jurisdiction to try?
Lordship, I am staying in Assam only, Lordship.
You are staying in Assam. You may stay in Assam, but you are an employee of APP. You may stay in Delhi also. So we dismiss it.
Lordship, some more time may be allowed. Lordship.
No, for what purpose?
So,
This, your contention has been answered by this respondent number 3. You are in APP. The commission can inquire. Commission will not punish you. Huh?
yes, Lordship.
Okay. We dismiss.
Lordship, next week, Lordship.
Next week,
Lordship.
Monday.
Okay, Lordship.
Okay. On the prayer of Mr.
Yeah, Lordship.
K. Lawrence, counsel for the petitioner. This to Monday, give the date.
Online.
Yes.
My lord,
Hmm.
the department has not yet finally retrieved, my lord.
What is the matter about?
My lord, I am challenging the interim order whereby my lord, my service has been discontinued, my lord. I
Your service has been,
discontinued, my lord.
you have been discharged.
Sorry, my lord.
You come to the mic.
Yes, my lord.
You have been terminated from the service.
Yes, my lord.
Where is that order?
That is annexed 4, my lord,
Page
page
number
number 19.
19. You appear for Mr.
Steady council, Biavo.
Jamo.
Yes.
Where is Jamo?
You lost, Jamos engaged at Guwahati. Okay.
See, they say no fund has been allocated.
Yes, my lord. My lord, they have terminated me on the pretext of non-availability of the fund, my lord.
Yes.
Although, my lord, the department in 2020, prior to 1 year before my termination, my lord, they have, my lord, in page number 18, my lord, and
18.
3, my lord.
Yes.
They have appointed five peon, my lord, for 6 months, my lord. On one hand, they are saying that there is no allocation of separate fund for this post, and on other hand, my lord, they are appointing new candidates, my lord. And my lord, I have been serving since 2005, my lord, to 2021, my lord.
Any instruction in the matter?
Your Lordship, we have received paralyzed reply from government, but we were not able to file affidavits.
Why?
So please, on next, on Monday, we have filed this affidavit.
What is there in the paragraph comments? What reason has been given? Okay, let them file affidavit.
My lord.
Okay, had Miss B. Permit, learned counsel for the petitioner and Mr. Okay. Learned counsel appearing on behalf of Learned listening counsel for the education department who submits that paragraph's comment for filing of a counter affidavit have already been received and the same and the same would be filed within a week.
Yes.
Huh?
Yes, ma'am.
Okay. Within a week. In view of the submission, will list it after 2 weeks.
My lord, this shall be the final last chance because
You file it next week, huh? Since you have already received the instruction. Okay.
God bless.
May I, Lordship?
Yes.
Lordship, here, all the, as I have, it has been come to my knowledge that all the alleged contempt has been transferred. So I may be allowed to inflict
Okay.
for new incumbents.
How much time?
Also 4 weeks time.
Okay. On the prayer of Mr. Vita Pudi listed after 4 weeks.
Lordship.
And the council for the petition.
Obliged.
My lord, we have complied the court order.
Complaint.
Yes, my lord, I have just received a complaint
Okay.
order, my lord.
Then we'll close.
However, my lord, I have talked to petitioner, my lord.
Huh?
I have just talked to petitioner, my lord. They informed me that the department did not release the amount, my lord.
Lordship, actually, the
Maybe-
direction was for
Let us
extending service benefits.
see the direction. Let us see
And
the
we have
direction.
already passed an order for extending all the service benefit. So maybe salary is not being released because there is some issues in increment and all. So it will be released in due time.
Let where is the direction of this court?
The Lordship, direction is at
Annexure one, my lord,
Annexure 1, Lordship.
page 16, my lord.
Yes.
So operative portion is
And operative portion is at 27, my lord. Last part, my lord. May I read, my lord?
Yes.
It is made clear that on reinstatement of the petitioner, all the service benefits shall be extended to him as per entitlement, my lord.
Make clear that administrative service. Okay, all the, okay, yes. Where is the affidavit?
Lordship, we have not filed any affidavit yet.
You have not
but
filed
we have
affidavit. What is that order? Let us see. Mr. Margedi, learned counsel for the petitioner. And Mr. M. Ete, learned counsel for all the respondents.
Sole respondent one.
Okay, so
Secretariat.
for the sole respondent. This contempt petition has been filed alleging violation of the order dated 30/11/2021, passed in WPC 214/2021. However, while setting aside the suspension order of the petitioner with a direction for reinstating the petitioner in the service, it was further directed to provide all the service benefits to the petitioner as for entitlement. Full stop. Mr. Ete, learned counsel for the sole respondent, has produced before this court an order dated 21st April 2023, issued by the respondent, issued by the sole respondent, the Secretary, Land Management, Government of Andhra Pradesh, by memo number LMD-1-4/2021/E-16-705. Whereby it has been indicated that after the suspension order of the petitioner was revoked and reinstated in the service, all other service benefits have been indicated to have been provided to the petitioner. Most accordingly, Mr. Ete submits that the order of this court passed in the writ petition has been complied with by the aforesaid order issued by the sole respondent. A copy of the said order has also been furnished to Mr. Margedi, learned counsel for the petitioner, who, while agreeing that the order passed by this court in the writ petition have been complied with, but makes a submission that he has an instruction from the petitioner that the service benefits, the petitioner is yet to receive the service benefits.
Yes.
Also, once the order, after issuance of the order dated 21st April 2023 by the Secretary Land Management, Government of Andhra Pradesh, there cannot be any impediment on the part of the petitioner from receiving the benefits in terms of order dated 21st April 2023, issued by the Secretary Land Management, Government of Andhra Pradesh. Full stop. The petitioner may have not received the monetary benefits mentioned in the order dated 21st April 2023.
Lordship, there is some issues in fixing his yearly increment and his scale. So that is fixed, then it will release. There is some issues in that.
May not have been received as the monetary benefits mentioned in the order dated 21st April 2023. which the petitioner, which the, you just a moment. You stop where I said that there cannot be any impediment, on the part of the petitioner to receive the benefit mentioned there. You stop there and start and don't that first. In view of the above, I find that by the order dated 21st April 2023, issued by the Secretary Land Management, Government the respondent number hearing, the order passed by this court in the writ petition has been complied with. In view of the above, no case, in view of the above, this contempt petition shall stand closed. Full stop. A copy of the order dated 21st April 2023, issued by the Secretary Land Management, the respondent number 1 here, by the memo number so and so, as produced by Mr. M. Etin and the council representing the petitioner, as the respondent, sole respondent, is taken on record and shall form part of the record, which shall be marked as X for identification. You will receive in due course.
Yes, my lord.
You will receive in due course.
Yes, ma'am. All right.
May I apply, my lord? My lord, item number 20 is contempt petition. My lord, contempt number 1, 2, 3, 4. In fact, direction was on 8/9/2022 that the respondent number 4 has to deposit money, and then respondent number 3 has to within 1 month, and then respondent number 3 has to disburse to the beneficiary, my lord. But it has not been done since almost 10 months, my lord. So I'll just take to the operative person is in page 65.
65.
Yes, my lord. Para 10, my lord. Third line, my lord. Third. The fourth line, my lord. May I read, my lord?
Yes.
Accordingly, it is directed that the acquiring authority, more particularly respondent number 4, shall deposit the assets amount rupees 35,94,01,935. 35 crore 94 lakh 1,935 only in the account of Deputy Commissioner under respondent number 3 within the period of 1 month from the date of the passing order, and respondent number 3, Deputy Commissioner under district shall disburse the same to each of the beneficiaries within the period of 15 days after such deposit, my lord. This was the direction, my lord. But then now it's almost 10 and then this impugn order was passed, my lord, is on page 61, my lord. That is page 61, 8/9/2022. 61, my lord.
Yes.
It's if I count from this that of order, it's almost 10 months, my lord. And it seems especially the respondent number, the secretary and the director, they are not complying this direction, my lord. Otherwise, the respondent number 1 and 2.
Who is respondent number 4?
Yes, my lord.
Who is Deputy Commissioner? He has been directed to deposit.
No, the deposit is respondent number 1, my lord. Here content number 1, content number 1, content number 1, my lord. Deputy Commissioner is respondent 3 in our writ petition.
They'll deposit the assessed amount in the account of Deputy Commissioner.
Yes, my lord.
Who was the respondent number 4 in writ petition?
Writ petition number Deputy Secretary, Director, and then we are.
Who was the respondent number 4 in the writ petition?
Oh, respondent number 4 is the commanding officer.
Okay, commanding officer
is content number 1, man.
Is respondent number 1 so far.
Yes.
He has not yet committed contempt.
Yes.
See, he has been directed to deposit this much of amount?
Within
in the
1
account
month.
of Deputy Commissioner. It has not been deposited.
Not yet, my lord.
Commanding officer.
Commanding officer, my lord.
You are
Almost
representing-
10 months, my lord.
You are representing.
My lord, I am representing on behalf of respondent number 1
Ah.
in this contempt matter, my lord.
Ah,
My lord, we have already filed affidavit. And as per the affidavit, my lord, we have specifically mentioned that once the my lord approval and the my lord the approved rate done by the my lord the secretary line management, we are ready to deposit, my lord. By latest information, my lord, the instructions which has been received by me from my lord the.
is there any stay order from the Supreme Court?
Lordship,
No, that no.
actually, Lordship.
No, this, yes, you had,
Yes, Lordship, that is Lordship in contempt 28.
Huh?
Lordship, contempt 28 is for WPC 175. That is for, it's a same stress of road. It's a contempt 28 is for 0 to 6 kilometer. And this contempt 47 is for 6 to 18 kilometer. The issue we raised, the deferment raised was same for the rates. And in contempt 28, Manaksha Taplab, the Supreme Court has already stayed the matter. And it's due hearing on August 4. And Lordship, if you see page number 61, Lordship, of the order which they are, filing this contempt, Lordship may see the paragraph number 2. The subject matter of dispute in this petition within a very short compass. In fact, the principal cause of action has already been adjudicated by this court in earlier round of litigations being 240, 128, 175. All this matter has already been stayed. And this order is flows from this order. That order which has been stayed. Lordship, this order flows from the order passed in WPC 175, which has been stayed now. Therefore, it has a cascading effect on this contempt.
Okay.
Therefore, last occasion, I have prayed for taking both contempt together for better understanding of the court and us.
No such order was passed.
No, Lordship, that time, Honorable Court observed that this prayer may be considered in the next hearing.
Okay.
Therefore, Lordship, still I'm praying for
Okay.
taking together of both the contempt.
Which contract case? 28.
28.
Okay.
Manaksha Taplab.
Will you sit together?
It can be, Lordship.
The order is separate, my lord. And in this case, the rest.
This order of the learned single judge is based on the order passed in WPC 175 April of 2020.
Yes, Lordship.
Is not it?
Yes, Lordship.
That is the basis.
Yes.
That basis has been stayed by the Supreme Court.
But then this is a separate.
You don't have legs to stay.
But this is a separate petition, my lord. Even if the contempt petition is pending, also, my lord, there is no, there should not be an impediment to even to deposit, my lord. There is also a FX judgment which said that during the pendency of the.
And who has challenged this order passed in 175?
Lordship, we challenge state government.
You means who?
State government.
State government. Then why have you not challenged this order also?
It's also been challenged. It's
Acquiring authority is the grief, my lord, not the state government.
Oh,
this order also, Lordship, we challenge and it's pending now. Condonation of release.
Just
still in-
condemnation of release. Okay. As spread by Mr. Ete. M. Ete, learned counsel for respondent number
2.
2.
In contempt.
This
In contempt, Lordship 3.
3.
Lordship.
Well, here our instruction is, well, by this later, written to the deputy commissioner for furnishing the account details for the for deposit of the amount is.
Oh, you want to deposit?
There is a several correspondence made to the deputy commissioners. We may be allowed to deposit the amount since we don't have any grief or we don't have any issues on the rate fixed by the department. At time and again, we are making correspondence to the department, deputy commissioner more particularly. The deputy commissioner is saying that there is no approval from the state government. Therefore, the amount whatever is done by the district administration.
Anyway, it's okay.
Therefore, it is our submission before your lordship is we have already complied with the order passed by this honorable court. We are ready to deposit as directed by this honorable court. However, because of the only on the part of the deputy commissioner as well as the state government, we are not in a position to deposit the amount. Time and again, ministry is asking for the matter, the entire details, so that amount can be transferred to the concerned deputy commissioner. Madam.
All right, all right. I prayed for by Mr. M. Atil, counsel for the, which respondent here?
Contempt number 3 here.
Respondent number 3. List this contempt case along with contempt case number 28 of 2022. It will do?
That's it. Let's say, since the next date of hearing in Supreme Court is 8 August, matter may be listed after 28 August, because I'll be out of station till this time.
Okay, after 28 August.
On or after, Lordship.
Okay, on or after 28 August. Okay. 2023.
License.
In this matter, no, I'm not representing any parties motion. But this against this judgment also, if state file appeals and modification has been done.
What is the judgment? To we are alleging violation of 254, WPC 254.
Close. In appeal also, I represented the state.
29/7/2022.
Kindly see the paragraph 22. In this judgment also, two-fold direction was there also. To consider the representation and at the same time to provide alternative accommodations to the petitioner's house. In that judgment.
A single judge's direction was to consider the
To consider the representation
and allocate
and to allocate
an
alternative
alternative
accommodation to the
place.
petitioner.
Okay.
So we contended that lawsuit when we are given the liberty to consider the representation lawsuit. Then direction to accommodate the alternative remedy, alternative accommodation is not proper lawsuit. In this modification order lawsuit. So for considerations of representation is concerned, that has not been lawsuit interfered.
Consider to provide the basic amenities.
Basic amenities. Because in that
Electricity,
petition, they refuse to the provided alternative accommodation lawsuit on the counts of the civic amenities are not available in the lawsuit. By this judgment lawsuit, the Honorable Division Benches directed us to provide civic amenities their lawsuit and then directed them to shift their lawsuit or else to have the house rent allowances as per the law.
All right. None appears for the petitioner. However, Mr. Attorney, just now. Yes. No, before the non-appears, don't wait. This contempt petition has been filed alleging violation of order dated 29/7/2022, passed in WPC 245/2022. Whereby the respondent authorities were wherever the respondent authority was directed to consider the grievances projected by the petitioners in their representation and allocate an alternative and suitable place where they can be accommodated, Full stop. None has appeared for the petitioner. Post of Mr. S. Taplin, London Senior Government Advocate, however, has placed a copy of the order dated 9/6/2023, passed in WA 1/2023, wherever the direction given in the order dated 29/7/2022 in WPC so and so has been modified by directing the respondent authorities to consider to provide the basic amenities like electricity and water in the alternative accommodation at Lehi Village, Nahalagan, or to provide house rent allowance admissible to the as admissible, full stop. Since the order dated so and so passed by the single judge in WPC so and so has been modified in the by the order dated 9/6/2023 passed in WA 1/2023. This contempt petition stands closed.
May I, Lordship?
Yes.
Lordship, on last occasion, my lord had directed respondent number 1 and 2 to file their affidavit in opposition, and private respondent number 6, 7, 8, and 9 to file their affidavit in opposition along with their wakalatnama. And the matter is regarding the impugned renewed registration certificate of All Arunachal Pradesh Divyangjan Welfare Society, which was illegally and arbitrarily issued by the respondent number 2. In also is given the position and domain in the position of the respondent, private respondent 6, 5, 6, 7, 8, and 9.
Yes.
My lord, I am for the respondent number 6, 7, 8, and 9.
Yes.
On behalf of this one, we have prepared the affidavit, but to sure in, we are unable to make contact with our client. So some time may be given.
Yes, Rira. 4 and 5.
3, 4, and 5.
3, 4, and 5 have filed affidavit.
Yes, they have filed their affidavit in opposition. 1 and 2 and other private respondent. My lord, 2 is the registrar of societies.
That will be required.
Yes, that will be required.
Yes, Rira. You are representing 2 also. Had Mr.
L. Teni. Licha Teni.
L. Gini.
L. Teni. Teni. Teni.
Teni. Teni.
Yes.
Had Mr. Licha Teni. Learned counsel for the petitioner. Mr. I. Learned additional senior government advocate for the for respondents 1 to 5 who submits that counter affidavit by the respondent number 3, 4, and 5 have been filed. And it may not be required for the respondent number 1 to file a counter affidavit. Also, he however pressed for some more time to file counter affidavit by the respondent number 2. Is not it? Heard also Mr.
El Taj.
L. Taj, learned counsel for the respondent number 6 to 9,
Kindly provide extra copy.
who submits that
Extra copy, please.
counter affidavit by the respondent number 6 to 9 is ready.
Yes.
And the same will be filed within how much time?
My lord, we are unable to make contact with our client. So
Okay, you try your best to contact
Yes,
us.
yes.
You will record how much time?
No, sir, we will be needing because they have to provide extra copies to us also. Because whenever they provide.
Okay,
extra
all,
copies,
okay,
accordingly
all,
we-
all right. Is ready and the same would be will be filed shortly. In view of the above, list it after 4 weeks to enable the respondent 2 and 6 to 9 to file counter affidavit. List it after 4 weeks. Okay. There is he's mentioning some issue of non-furnishing of extra copy. Sort it out.
Actually, we have served the copies, but
Do you have the receipt?
no, I think it will be in the report of
No, say,
Service.
just 3 copies.
All right, you sort it out, huh?
Yes.
So that on the next step, this issue is not there.
Yes, I will serve it to them.
I know, respondent number 2 and 5, yet to file their affidavit, man.
2
and 5.
Okay, what is this matter about? CCULE.
Income tax matter, my lord. The assess to the tune of my lord's a sum of 3 crore 94 lakh 69,000 and 944, my lord.
Okay,
The contention of the petitioner is he is exempted under the income tax act provisions, my lord. So therefore, he is not liable to pay any taxes, man.
have you filed affidavit? No.
My lord, respondent, my lord, in fact, they have their own standing counsel, the income tax department, as per the instruction received from the my lord. I am only representing respondent number 1, Union of Vidya,
Okay.
my lord. So
All right.
therefore, basically, 2, 3, and 4, 5 will be represented by their separate standing counsel. my
So
lord.
it is they who will have to file affidavit, is not it?
In fact, I'm told affidavit on the part of the respondent number 3 and 4 has filed.
It has been filed.
Yes, ma'am. And that will cover the document. So matter may be fixed for hearing. Respondent number 3 and 4, ma'am.
No, I don't find any. There's nothing on record. Heard Mr. K. Lolan.
The other, man.
Huh?
The other.
Oh, the other.
Yes, ma'am.
The other learned counsel for the petitioner, Mr. M. Kato, learned DSGI for respondent number 1.
1, ma'am.
None appears for respondent numbers 2, 3, 4, and 5. In view of the above, list it after 6 weeks
My lord, there is an interim contact.
for filing of a counter affidavit by the respondent. Interim order pass earlier shall continue till the next date of list.
Yes, Acham.
Deeply obliged, ma'am.
May I please, your lordship.
Yes,
And for the petitioner lordship, in my village, on 12th of May 2017, 28 houses were burned down, including our house, lordship, and losses that we suffered was quantified at more than rupees 1 crore, lordship. This was So after that, some inquiry was done, but it was not a full-fledged inquiry. Lordship may see Annexure 1, Lordship.
Page number.
Page number 12. There was an order passed by the ADC in charge Deputy Commissioner saying that the office is in receipt of information that a fire mishap has occurred at Kerang, Kayang Circle on 11/5/2017 afternoon. In this regard, ADC Rumgong and ESC Kayang is hereby directed to visit the site of occurrence and assess the loss of property, lives, and submit report along with photographs to the Deputy Commissioner, Siang District, Pangan at the earliest. Now, as part of this, a meeting was held, that is on 12th May. Lordship, this is the next page, page 12. Here, Lordship, all the administration and other officers attended, and in the points, Lordship, it is mentioned. Point number 2 specifically, the last paragraph of page 13. During the verification of the spot, the board members found that there was no proper LT line wiring in all the posts erected in the village. Power department is directed to look into the matter at the earliest to avoid any kind of fire accident in future. So basically, during the spot verification, it was found that there was no proper LT wiring. So this may have caused the fire. Then it was also said that relief may be given to the persons who have other victims, Lordship. Thereafter, Lordship, we made a complaint. I made a complaint to the officer in charge. This is page 15, Lordship, saying that with due regards, Lordship, page 15, this is on 14/5/2017.
Yes.
Subject FIR. With due regards, I'm putting the FIR after Tamon Riang against Tamon Riang on 11 May 2017. I said made this complaint against this Tamon Riang because at that point of time, the villagers had said that the fire started from his house. But later on, it was found that he was not even at home when this occurred. Now, Lordship, thereafter, I also made a complaint, appeal to the Deputy Commissioner to look into the matter. This is, Lordship, page 17. An appeal for fact finding about Kerang 1 fire accident by SIT, probe or judicial probe, magistrate inquiry, / police investigation. With due regards, I as a capacity of the president of the Kebo Gambo Welfare Society would like to put forward regarding the very sensitive matters of repeated fire accident in the Kerang 1 village under Kayang Circle of the Siang District, Arunachal Pradesh. We have decided that repeated fire accident Kerang comes under suspicion clouds whether repeated fire accident is due to miscreen or unintentional human error or electric short circuit problem. Hence, enclosed are articles containing point raised by the Kebo Gambo Welfare Society for immediate SIT probe, / judicial probe, / ministerial inquiry, / high profile police investigation. Therefore, appeal to the media fraternity house of for publication. Now, Lordship, I have mentioned repeated fire incident because, Lordship, before this 2017, the last one was in 2014. There have been at least 3 such incidents, Lordship. So because of that, we made this appeal before the Deputy Commissioner to conduct some kind of inquiry. We had also demanded SIT probe or judicial probe into the matter. Now, Lordship, thereafter, Lordship, an inquiry was done by the police, Lordship. This is the forwarding of the inquiry report is at page 20, Lordship. The inquiry report itself is at page 22, Lordship. Lordship may see the second para. This is, Lordship, might be relevant. Further, in order to ascertain the actual cause of the fire accident, I have examined the victims, villagers, and persons who were present in the village during the time of breakout of fire accident. I have thoroughly examined the victim, namely Sri Tamon Riang, from whose house fire started. On being examined, he stated on 11/5/17 he was staying in village and was playing cards in the residence of Taken Jerang, son of Karma Jerang, located in the lower side of Kerang village, with Srimati Yatum Gammi, wife of Tasin Gammi, Srimati Oming Gammi, daughter of late Yatum Gammi, Srimati Yamon Tapak, daughter of Tangor Tapak, and Srimati Oir Riang Jamo, but Sri Taken Jerang was not present in the house during that time. He stated that they started playing cards at around 8:30 hours and played till 1300 approximate, exact time not known, as he was not wearing a watch. Suddenly, some person shouted, fire broke out. After hearing this, he ran towards the upside of the village. On reaching, he saw his thatch house was already caught fire in roof portion. So basically, the police said that the fire started from the house of Tamon Riang, and he was not even present at the house. And the fire started from the roof of the house. Then from below, Lordship, fourth line in the second paragraph, Sri Takir Paul, son of late Tajo Pao, has stated he was present in the house during fire accident and heard loud sound. When he looked towards the direction, the sound that fire already caught in the roof of the thatch house of Tamon Riang, he stated the cause of fire may be due to electricity short circuit. During inquiry, I have engaged many local sources to ascertain the cause of fire, but they could not establish the exact cause of fire. Also, I examined two persons, namely Tasar Pavin, Srimati Yakut Riang, both has stated approximately 15-20 minutes before the fire incident broke out, they were separately coming by footpath near the hut of Tamon Riang at that time. They did not notice any smoke or any fires smelling from his hut. Also, I have examined many villagers, namely Tabang Pabo, Taro Darang, Tamur Taga, Tasigammi, Tapir Darang, and Tamjom Gammi. They had same opinion that the cause of fire might be due to electricity short circuit. During inquiry, I have made every possible effort to ascertain the trace cause of fire behind, but no foul play was detected behind the fire accident. So the police report basically said, after examining many people in the village, that the fire started from the roof of the house, which is quite impossible if it is if there is some foul play. Then the villagers, they thought that the fire might be due to some electric short circuit. Now, Lordship, page 23 is the damage and loss assessment. This is by the EAC, Extra Assistant Commissioners, Yang District. This is 15 May. Page 24 is the damage and loss assessment report. Here, Lordship will see the damage has amounted to rupees 1,27,93,000. Now, Lordship, after this, there was a report on page 26, Lordship, which was sent to the Disaster Management, Director Disaster Management. Page 26 is the covering letter. And please find herewith a report of the fire accident which occurred on 11 May, Kerang, Siang District, for a kind information and further necessary action. This is the report. And page 27, then Lordship, page 28. Other than this, Lordship, the perfunctory, I would say, inquiry made by the police, there was nothing else, no other inquiry had taken place, Lordship. So therefore, on page 28, I have made a prayer for proper inquiry into the matter, because it is not the one time. Fire incidents used to be quite frequent there. So this is page 28, Lordship. This is on 4th of October 2017. After mentioning all the incidents I've made a prayer saying that to set up a proper inquiry committee for fact finding and prayer order to copy for which Act of Finance I shall highly appreciate your Honor's administration. Now, Lordship, nothing was done here. Later on, Lordship, I have met RT application also because in the village, even though the fire had started from Tamon Riang's house, everybody has stated, even the police report has stated that the fire occurred from the thatch of the roof, Lordship. And the person who was there was not even, the owner of the house was not even present at the house. And there was no smell of any fire coming from anywhere else. So we had, the villagers, including me, had suspected that this might be due to the electric fault. And so I had made the RT application also. Now the RT application shows that there is no proper wiring in the village, Lordship. In place of 30 electric poles, LT poles, only 15 were there. Lordship, the RTI report is at page, starts at page 29, Lordship. And my query is at page 32, the type copy of which it is at page 33. I have asked for status of electrification aids work executed before 2014 and after 2014 at Kerang 1 village at Kaing. I have also asked for total electrical pole erected before 2014 and after 2014 to 18. Then status of LT line before 2014 and after 2014 to 18. Then types of sanction and work executed at Kerang village after 2014 till date of Kerang 1. Kerang 1, it means the village actually. So in reply to this is page 35, Lordship. In reply to this, they have said the total number of LT poles as per the DPR has Lordship out B, point B. Total number of LT poles as per the DPR was 13 numbers. However, as per handing and taking over of village, LT poles erected before 2014 is 12 numbers. And after 2014 to 15 as per the DPR, of the total number of poles is 72. However, due to non-submission of handing and taking over note, this office is unable to furnish the accurate number of poles in the as on that. So, Lordship, even the electric poles which were supposed to be there is inadequate. And in fact, this reply regarding the 72 number of poles, that is also evasive, because they have said that they are unable to furnish accurate. This is because, Lordship, as per the DPR, things have not been done, Lordship. Lordship may see the photographs also, which I have enclosed, Lordship. The distance between one pole and the other is more than much more than the distance which is required in electric pole, Lordship. So we were suspecting that this might be the cause of the fire, but no inquiry has been done. We had given a legal notice also to the department. In reply, the department has stated we have done some kind of inquiry, self-made inquiry. This is at page 53, Lordship. There was an office order by the executive engineer, Rumgong Electrical Division. He had constituted a 3-member inquiry, consisting of his own officers only. Then page 54 is the submission of inquiry report. Page 55 is the inquiry itself. Lordship may see page 55. A very casual sort of inquiry has been done. Lordship may see page 55. The inquiry committee visited Kerang 1 village on 26/7/17 and inquired about the possible cause of fire, which engulfs 26 houses on 11 May. This is also wrong, actually. The houses are 28 on 11 May 2017, according to the villagers, the fire started from the house of one Tamon Riang and quickly spread to the nearby houses. It was due to negligence of the owner of the house and not from the electric short circuit. Earlier in 2015 also, it was due to negligence of the owner of the house which causes fire. The service connections to the houses in the village are well connected from the poles. The DTS is far from the village and the LT pole line is good shape. So the possibilities of cause of fire due to electric short circuit is ruled out. Finally, the committees of the opinion the exact cause of fire was due to negligence of the owner of the house rather than electric short circuit. So a better reading of this report is very clear that it has been done in such a manner simply to wash off whatever responsibility they are there, because it is told by everyone in the village, by the police report also, that the owner himself was not there and the fire started from the roof of the house. So it cannot be due to the negligence of this house owner, Lordship. So, Lordship, this honorable court had heard this matter last time, and by order dated 21/12/21, had asked me to verify whether there is any statutory duty cause upon the power department to conduct inquiry in such cases, Lordship. I have seen that as per the Electricity Act, Lordship, Section 161, in such cases of incident, Lordship, there is the electrical inspector is supposed to hold an inquiry, a proper inquiry. And I don't know whether electrical inspector has been appointed or not, but there is an order according sanction for creation of 25 posts in various categories, in which establishment of electrical inspectorate, under which this electrical inspector is also supposed to be appointed. The respondent counsel appearing for the power department, of course, would be the best person. This is the order, Lordship. So, Lordship, at the very least, the respondent authorities should have conducted a proper inquiry. They have simply brushed off everything, Lordship. So my only prayer is that a proper inquiry may be directed, Lordship.
Yes.
I may also, Lordship, mention again that this is not the only time that the fire incident happened. It happens quite repeatedly there. 2017 was the last one, Lordship. So that is why we were very concerned about this.
Yes, Parme.
If my lord may kindly turn to page number 35 of the petition.
Yes.
Now, submission of the petitioner made, my lord, there worry, my lord, this, my lord, fire accident, my lord, is happening repeatedly, my lord. Now, if my lord turn to page number 35, my lord, this is RTI reply, my lord. A status second, my lord, partner in A, my lord. Kerang village was de-electrified due to fire accident on 11 and village were re-electrified on DD scheme 2017, my lord. Now, ultimately, it is accepted by the power, this fire accident happened in the 2015 also, my lord. 2015. At that point of time, there was no electricity, my lord. This was, my lord, re-electrified only in 2017-18, my lord. Again, my lord.
When was the electrification completed?
Earlier, my lord, it was 2009, my lord. But the fire accident, my lord, it was de-electrified in 2014, my lord. 11 even 2014, my lord. Now,
De-electrified?
Yes, my lord. Part of the Kerang village was de-electrified due to fire accident 11 even 2014, my lord.
Where are you reading?
My lord, page 35, my lord, close one, my lord, a second part, my lord. Second part of my lord. Status of the electrification, it worked, my lord, before 2014, after 2014 Kerang village 1, my lord. Second part, my lord. Now,
What do you want to show?
now I am indicating this, my lord. Ultimately, fire incident also happened, my lord, as per the condition of petition of itself, my lord, 2015, my also, my lord. At that point of time, my lord, there was no electrification at the Kerang, my lord. Now we have our epidemic. We are saying, my lord, in terms of the petition, my lord, it is accepted, my lord. There is inquiry, my lord, by the administration, my lord, by the police, by my lord, and the department itself, my lord. Now, nowhere, my lord, they it say that, my lord, it was due to the this electric short circuit, my lord. Now, in such a situation, my humble submission, my lord, evoking this jurisdiction, my lord. Ultimately, when, my lord, categorically, my lord, the department, my lord, is saying, my lord, no, their fault was not on our part, my lord. Based on some record, my lord, my humble submission, my lord, presumption of this report 226, my lord, should be goes in our favor, my lord. Now, if they are sure, my lord, this happened, my lord, due to electric some, my lord, they have a remedy, my lord, to lose to pursue their FIR, my lord, as they have also lost FIR, my lord. FIR is also there, my lord. Now, this incident of 2000, my lord, 17, my lord. Our part, my lord, we have done, my lord. I humbly believe, my lord. It is not that, my lord. We, my lord, they have also annexed, my lord, in page now 55, my lord. This is 3-member, my lord, committee, my lord. This is by the department, my lord. My humble, ultimately, my lord, if they are agree, my lord, they are saying, my lord, this is due to electrification, my lord. They need to challenge, put on challenge this all order, my lord, by our department, my lord, and by the report of the police officer, my lord. Until now, my lord, that is challenge, my lord. Any order, my lord, this court, my lord, overlooking this, my lord. My humble submission, while evoking the rejudication, my lord, would not report for impede, my lord. If I may allow to read, my lord, page number 22, my lord, again, my lord. This, my lord, 22, my lord.
22.
The earlier read by the, my lord, petitioner, my lord, page number 22, my lord.
Yeah, read.
Yes, my lord. I am also reading from, my lord, this para second. Further, in order to ascertain the actual cause of accident, I have examined the victim village and person who are present in village during time of broke out the incident. I thoroughly examined the victim persons with such and such from whose house by start. On being examined, he stated that on the 17th, he was staying in village and was playing card in the residence of Sri such and such in lower of Kerang village with Simoti such and such. Now, my lord, will see, my lord, this owner, my lord, from where, my lord, the fire started, he was present, my lord. And normally, my lord, in the village side, my lord, this is not this is all the house, my lord. It is made of, my lord, from Texas, my lord, leaf, my lord.
Okay.
Now, in such situation, my lord, this owner, my lord, though he was present in the house, my lord, he went there other side to play card, my lord.
No, what have you written in your affidavit?
Epidemic, my lord, we have said, my lord. Short epidemic we have filed, my lord. We are saying that we are denying, categorically denied that, my lord, the allegation of short circuit of cause of fire escape SM is baseless, my lord.
Okay.
Short circuit, my lord.
All right.
Yes, my lord, there is a on allegation of non-responsive, my lord, by the petitioner, my lord. We have said that, my lord, the minor meeting is there, my lord. This is part of Annex 1, my lord. Inquiry report is there, my lord. That only, my lord, that is our contention, my lord. We are categorically denying, my lord, this happened, it's a short circuit, my lord.
All right. Anything else? Yes, Pangu?
Here, Lordship, from our affidavit, Your Lordship, we are stating that in persons to the complaint made by the petitioner,
You represent whom?
I'm for respondent number 1 and for DC, Your Lordship.
Okay. You have also filed affidavit.
Yes, Your Lordship.
Yes.
We are saying that in person to the complaint letter of the petitioner, a thorough inquiry was conducted by M. Lego, Sub-Inspector, Police Station, Crime, and the inquiry report as submitted by the officer was made available to the petitioner. And Your Lordship, in the report, Your Lordship, the cause of the exact cause of the fire was due to the negligence of the owner of the house, Your Lordship.
Hmm. Okay.
Oh, yeah. Mr. Parme, Lordship, has actually stated a wrong fact. That is why I want to bring on record, Lordship. He has stated that in 2015, fire incident took place. And at that time, the village was not electrified, Lordship. But it is never my contention that fire accident took place in 2015. In all of the records, Your Lordship will see from my side, there is never been a mention that the fire accident took place in 2015. The fire accident took place in 2014, not 15. The only place where Your Lordship will find that the fire accident, some fire accident took place in 2015 is their inquiry report itself. The inquiry report submitted by the power department itself. So that is totally wrong, Lordship. That is their Lordship, their fact, Lordship, not mine. Now, Lordship, that in 2014, it is clearly mentioned that it was de-electrified due to a fire accident, Lordship. In my representations everywhere, Your Lordship will find only 2014 and not 15. This may be made very clear, Lordship. Another thing is, Lordship, as per the Electricity Act, Section 161, the electric inspector is supposed to make a thorough inquiry, Lordship, in such cases of fire mishap, Lordship. They have not done any inquiry, simply, Lordship, brushed over the matter and saying that it did not happen due to electric short circuit. And also, Lordship, the submission given by Ms. Pango, saying that the fire incident took place due to the negligence of the house owner. Now, that is also contrary to her records, Lordship, because the minutes of meeting held by the administration itself have said that there was no proper wiring, and this may be the cause of the fire. Nowhere it is mentioned it is due to the negligence of the house owner. The narrative of the house owner being negligent is only that of the power department and not anybody else, not even the police department, Lordship. So the respondents, more specifically, the power department is actually duty bound under Section 161 of the Electricity Act to conduct an inquiry. I am seeking for an independent inquiry because of the inquiry report submitted by them, which is, as I pointed out, totally perfunctory. Because of that, I do not trust that they will conduct a proper inquiry. That is why I am before Your Lordship. Oblige.
Okay, all right. Dispose of. We'll pass order.
Oblige.